You are represented today by Attorney Ben Chambi, and he will be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court ordering witnesses appear in your defense. You have the right to remain silent. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record. Or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the 180-day misdemeanor of high BAC. Is it still your wish today to waive all these jury trial rights and plead guilty to the misdemeanor 180-day high BAC misdemeanor? I'm going to have you raise your right hand as best you can. Do you solemnly swear affirm to tell the truth, whole truth, and nothing but the truth under penalty of perjury? All right, I'm going to bring your attention back, sir, to May 13th of 2023. Were you operating a motor vehicle open to the general public on May 13th, 2023? That would be on Bement Street and South Pennsylvania Avenue.
Yes.
All right. And at the time, later, did you learn that you had a blood alcohol content while you were driving the vehicle of over a 0.17?
Yes.
I think that covers. Let's see. All right, anything towards the factual basis for the amended count one, Ms. Fortuna Gill?
No, Your Honor, the people are satisfied.
All right, Mr. Chambi, anything from the defense concerning the factual basis for amended count one?
Your Honor, I believe you covered everything, but just in case, I'll just ask this one question.
All right.
Mr. Sanabria Hernandez, were you driving the vehicle upon a highway that is on South Home Street?
Yes.
Okay. Perfect. All right. With that understanding, anything else, Mr. Chambi?
No, Your Honor.
All right. I find the factual basis to be knowing, voluntarily, and accurately made concerning the amended count one, which is high BAC. So we'll refer to probation because we've got to do a PSI and assessment on this. But probation, if they do it today, they may need your help, Mr.
Okay. That's understandable.
they may need. If they set it for another day, then they're responsible for the interpreter. But all right, so we'll refer to probation. The probation department is, as you know, one floor down, all the way to your right. That's where you should go after this, just to make sure you know when they may see you today, they may see you some other day. All right, and then we'll set sentencing date for, and that's got to be 6 weeks out.
6 weeks?
Yeah.
Oh, 60 days. Okay.
It'll take some time for the assessment and for them to do the report. So I think they're asking for 6 weeks.
Duras 6 semanas para investigar.
May 15th.
Okay, that's 4 weeks.
May 29th.
May 29th. 29 at 9 o'clock. All right, we've set sentencing for May 29th at 9 o'clock concerning this matter. And then you should go to probation. They'll do a report for me and we'll see what options are available to us. All right. Anything else for the record in 26-00659, Ms. Fortuna Gill?
Not for the people.
I'll place the plea agreement and the advice rights in the plea agreement form. I don't think I had to go through because you had all the advice rights, but we did it anyway, just belt and suspenders.
And thank you, Your Honor.
Mr. Tomby, anything else on the record for this?
Once again, thank you, Your Honor, for asking. If my client or defendant could have the ability to work out of state until his hearing.
I have at arraignment, he was may leave Michigan for Indiana for employment purposes. Any objection to continuing travel out of state for work purposes, Ms. Fortuna Gill?
No objection, Your Honor.
All right, so I will make that a part of the order, that the order is continued. So Mr. Sanabria probably should carry something with him.
Yes.
Indicating it so he can show it to if he's stopped.
Thank you.
But
you did mention that the last time,
yeah.
and he is aware.
So we'll order that it continued out-of-state travel for work purposes. All right, we'll see you on May 29th at 9 o'clock. Thank you for your appearance today,
Thank you,
Mr.
Honor.
Chumby.
Thank you.
Y ahorita vamos a ir para allá abajo.
All right, Ms. Fortuna Gill, who's next?
Are you ready? Yeah, check your voices. Your Honor, I don't know that we're ready on anything.
All right.
Honestly, I think that I need some time to speak with defense counsel.
All right, and then I've got, and then let David know who to bring up if we need to bring anybody up.
Yeah. Okay.
But we've got, because the first 1, 2, and Brandon James and the first 8 are in custody, it looks like. 1, 2, 3, 4, 5, 6, 7. Everybody but Mr. Hackstad is in custody.
Thank you.
So that's most of the 830s and 9s. If we let David know if we need to bring him up, if not, we can just I'll rely on the lawyers to explain to their clients what's happening.
Okay, I'm hoping that we just need a very brief.
All right. So come get me when you're ready.
Thank you.
All right. I didn't know you were there.
Right on that one. Sorry, thank you. Um, wow, that one. We have everybody here. So that one's going
Something's
on.
already going on.
Is he,
Uh,
oh, he's in custody?
Yeah, he was.
Sure. And then we also have. Okay, I have to ask for continuance on that. Yes, because I have my officers here, but I don't have. Watching videos. So, yeah. If we find it. So we probably need to apply, so. Sure, yeah, I get it.
I don't want, I'm fine.
Yeah. Okay, and then. We have to put on Brandon, and get everybody here on it. Do you have the office on that one? There's an option on that one.
Barrel 10, 15 kilograms.
Needs to create account 2, account 1, or restitution. But count 2 is a felony, so.
Dr. Shields. And because I don't know, he just adjusted. So they got Dr. Shields. Park David,
Okay, you wanna run it?
general surgery. Okay.
And then I
So they
have,
got, there's a few more properties.
Roxy County,
I
they
have-
say, so a little bit, superior north.
She's gotta
towards
take,
Flint.
that,
Yeah.
with the offer on that.
No, not for
I-
this.
Okay, emailed yesterday.
Yeah, no, it was
She's
pretty,
taking-
they're like, I
She's
was that,
taking
so
general surgery.
it's coming from the north part, you
They
know,
gotta
the
take-
heel and St. John's and stuff really got hit. And then I felt, yeah, I felt, you know, the sirens went on, and all that.
No, I know.
Yeah.
I know.
The wind,
That's-
yeah,
you
the
know, my-
north side, yes. Yeah.
Oh, the other day, right?
Yes.
Yes.
While we're out, weekend, just like this.
I don't know.
Yes. The other night, not last night.
Yeah.
Nobody said you'd schedule for Monday also.
Which
Yeah.
facility are you at?
Yes.
I'm not gonna have, man and Steve, oh my gosh. Okay.
So you want to be higher than the
You think you're gonna run,
5:30 AC?
Okay, there you
Wilson and, Houston?
I forgot you bought it out yourself.
Alright.
And again.
Oh, I'm sorry, I got that one confused with,
Favorite cousin.
Brandon, I'm sorry, that's what I got. You're gonna run. Okay, what about Houston? On Hackstead, since I don't have my victim, I have to ask for continuance. Are you okay with just letting my officers go? Yeah, because he's gonna make me choose whether he wants to do continuance.
Yeah. Isn't too bad. So it's horse and shit. Start Simpson Street. So we got young items. I never heard of it. No. No, they no, they tell them, that's right. If it just, I'm in just Flores. People got you up here. Good morning, what's your name, man?
Amira
What's your last name?
Eccles.
Been subpoenaed. Okay.
Yes.
I know. Oh, yeah. Okay, so she said, She said she ate one, but you know, she ready for the smoke. She ready for the smoke. Whatever. Yeah, I mean, you just getting that check. Check's bad.
So they clear. They clear.
Ain't cheap people.
So. the Pennsylvania people want to buy, you know, examination, so. So.
I mean, just in general.
I have police officers.
Better choice.
Yeah, right. Yeah, I want to say better, maybe more.
Yeah, I say you're right. I think I can speak better. And at the age, man, you know. You won't be my age trying to figure out life. You know what I mean?
Man, I'm telling you.
Was last time,
Nope.
it was at least,
He's out.
yeah. Okay. And he has some change.
We find, I've been bouncing between two courts. We find
He was on.
Oh, yeah.
So, as part of his, they took into conditions.
Yeah. Oh, that's right. They could be there.
Yeah, so all last time. That one. When I call that number.
Oh. Are going to run Brandon. Or not James Brandon, sorry, just two Brandons. Correct, yes.
Okay, and then these two.
We're also gonna run Garcia. Oh, that one needs to be dismissal.
So, so the Nolly for, okay, I got you. And then Jacob Garcia, I guess
We
can-
don't do we do the dismissal on
Oh,
defense
okay,
motion
okay, I
or
got
whatever.
you,
So in the number two,
I got you, I got you.
for which one? It's essentially the same.
For, Mark Warkle, I'm probably just.
Yes. Yes, and then,
It's gonna be new.
yes.
So Garcia, I could probably just bring him up. He is,
I was hoping we could do Brandon first.
okay.
It would be a lot quicker, I think, and, you're like,
Oh, okay. I guess they want to run,
I hope. Did you get it?
Where
yeah.
Brandon.
Yeah,
And then Jacob Garcia.
yeah.
We know anything on the other two? Brandon.
She didn't say anything. Actually, I don't even know what Milk's with.
Yeah, I haven't seen him and Natalie at all.
Natalie's out here, but I don't know where Milk's. I'm thinking if he starts, by the time he starts, Brandon. the other- Well, I guess that's what's the issue.
No, you should have.
That is.
Right,
Yeah, yeah,
Oh,
yeah.
what am I into the restroom?
Okay.
So, I mean, if Judge wants to go on.
So now talk.
Bond after we talked on Wednesday.
Hackstad's not here.
Talking like, oh, right.
You're like,
You're very lucky, you're lucky.
Oh, he didn't show up. So that's right.
Yeah, that's it.
That's right. More than likely.
But then let them bond out before our meeting. Fire.
Yeah, he may show up. So yeah, if
what nice.
Judge wants to go on that, that seems to be the only one they got really together.
Yeah,
Yeah. He's down in jail, so if whatever judge is eating, he just let me know. I'll give him a judge.
Well, no, I mean, you're good, you don't need to wait for him.
Oh.
You need to, if she said that that's what you're gonna go next, then that's what, you can go ahead and go get it.
See, that's another thing.
I know, yeah. No, he lives kind of. So,
Oh, shit. Let me get him.
so, yeah,
Yeah,
I'll go, but I'll tell him that that's who you're going to get,
okay,
and then we'll be able to go on that one then.
that works.
I know, it sucks.
That's how it always goes.
That's how it goes.
I just like this stuff. I took an exam yesterday and I said, I'm done the rest of the day now.
What exam?
Exam skills. And I was really nervous about that one because I've been under the assumption this whole first semester that the exams are. Because it's like they do at your own pace kind of course. Like just
Yeah.
have a whole, like, not
But
locked
eventually
down.
you need to test your skills.
100%. I can get behind that, but I just thought this exam was going to be a book. And so I haven't been as invested. Like I've been doing the work and getting the grades,
Yeah.
but like I haven't been like fully. Anyway, so they sent an email last week. This is going to be a closed book exam. Hope we can have it go.
Well, at least you got notice. You didn't
So at
show
least,
up the
yes.
morning of.
And then it said in there, in the announcement, it also said, make sure like you practice the multiple choice to study like multiple choice. And that's the same. So.
Yeah, well, like, oh, nice. Thank you. Let's go.
So anyway, yeah, I just have one thing to do. It's already done. I just get to.
It'll be done. We're good. Oh my God.
I'll be back in office.
Right here.
But I'll recommendation to sit down.
Oh, sure. Sure. He'll get the best glowing recommendation from notes. Yeah.
Not you, though, sir.
It'll put everyone else to shame with how verbose it is.
Been a busy day, it's going pretty slow.
Well, it's busy for one person. And then, yeah, Haley. And then we all have to wait for her. So I'm trying to get out of here. I got a court over at 31:30. So if you guys don't get out of here, I'm gonna make you. I'm giving you work.
You know, this judge does sentence and agreements and caps, so you could kill it for 30 days.
Yeah.
Hey, Russ, this morning. Got caught in traffic, email master normal. Right.
Oh my
8 minutes
God,
late, and I show up
no.
and guess what? She's like, hey, you don't need to be here today. Man,
I know. Yeah.
I hate when that happens. It's
If
only
you're
happened,
texting your
it's only happened
driver,
twice. It's only happened twice.
Yeah.
Wow. I stopped her.
Pulled over.
I haven't told Todd, I can, only I can talk to him about this. Okay. Still on you. sucks because he has a nice car. I do like the car he drives. George. And I do like it's dark in there, but.
I know I can't tell like what time it is.
Obviously, it's not safe. They're over there. Like number one car in the city.
Really?
Yeah, so those Dodges, my God, I see them left and right in police reports. Yeah. So I'll only have, I can only take me as far as Fleet. Well, we went out to Cora.
Oh, last Friday?
On Friday, yeah, he drove Raleigh. And, you know, I was.
Yeah.
Raleigh's like sending pictures from the back seat.
Is it nighttime or is it daytime?
And then he had
You
to
don't
take,
know.
and then he had 3 drinks and had to drive him all the way back here to the car. No, but it's only get 3 of them.
Right, the cat.
Well, yeah, I only had 2, then George had us all closed off. Tell you a story. It, you know, I'm playing fights too, and here's a whole lot later, yeah. Well, because, yeah, it's a place where, yeah, so what they do is they just follow the rules, and have it very well printed.
I do have the officer here. Or, yeah. Oh, which one? Heredia? Yeah, which one? Oh, which officer? Yeah. You always say that. So only one I subpoenaed, so give me a second. Briggs. Okay. Would you like to go in chambers?
Yes, I would. You definitely want to see what the judge will have to say about
Okay.
immediate sentencing.
Okay, I will go give them an up.
If her office sent this. That was there.
Sarah.
I'll go. Hold on.
All right, expect me to come. Yes.
Thank you.
Rod, you must take the express elevator. You beat me up. Hell,
No, so she's with, Donnelly.
oh, okay, I got you.
So,
Should I go find Haley?
No, where's she back?
Smiling hard. She was smiling. I said, look, at least I thought it was crazy.
No, I never.
To be honest, I'm like, every day, I'm like, I be sitting next to each other. I be sitting here every time I go home, every time, and he's smiling.
In order to talk to him.
Yeah, it's crazy.
He's like, ain't no regular.
No, it's like
It's
a
like,
joke.
I know something I should be doing.
Yeah. Like the joke.
Yeah, bro, it's so funny. Ever noticed the last 5 months of the year? Like on Zoom. He just cool. He smiles.
On Hackstaff, it's gonna be an adjournment.
Yeah, I represent myself. Yeah, it's crazy.
Declaring on Brandon as running. Cleveland Castillo is going to be,
Oh, yeah, I mean, basically, you can say.
And it's cool to look at. All day. It's a different story. We don't staring at it bright, brightly, but it's bright.
Yeah, man. And then the crazy part, his face is almost strange.
I know, everybody looking at it, all like. I told, I told the you there when I said the James. I said that was everybody. I've been talking about.
Yeah, he's been doing it.
2-3 months I've been telling him, like, yeah, ain't a problem, but man, somebody gonna call him out for that.
What do you think?
oh, this is an adjournment, the stipend order we signed last night.
They talking about AWAM and all that.
Smile. Thank you. Well, they read the charges and you're smiling.
Aggravated life offense.
Yeah.
Smile.
Oh, yeah.
Crazy,
everyone.
crazy.
He didn't want to take it out.
Hey, next time you see it, I promise you. He always smiles. Always.
I'm used.
Always, bro. And like you said.
Yes.
Yeah, it's time to right, smile after the, like, after the cases.
They read out his whole charge. Give a smile.
But
She What's the number on it?
Tuesday.
No, smile, you're bigger.
I thought I was the only one that seen it. I was like,
10 seconds.
all right.
So for the 21st, what, and when do we do?
Did we already met, didn't we?
Yeah.
When we meet?
Last time I was on the 23rd.
Oh, don't worry about that. That's not.
Would you think they'd pick me up or?
You get all this shit.
No, but my release is here real soon.
Probably get it done. Probably get it done, right?
Yeah, she said she needs 10 seconds.
You don't got the dog?
It's probably longer than that.
No, he got put.
10 seconds. I know it's, you know, it's, man,
DR.
I think it must be, this gets all will be all right.
Yeah.
Cause some other stuff might start working itself out too.
Yeah.
Yeah,
Oh,
so DR, no, that DR.
BR, Brandon.
It's kind of my pet peeve because it's cat and mouse. BR.
It's BR.
Yeah. Your adjustments, you know, the adjustments.
Yeah.
Gotcha.
Oh, yeah, he is. He is 21st. Yep.
Both drug cases. Is that this judge or? Gotta be. Put the dog down.
Yeah, that's what kind of had us.
I know.
Got me earlier. I'm like,
I'll talk to you.
yeah, right. Yeah.
Yeah, I can't.
So, that's why you guys in jail. So, which one? Wait, wait. Oh, sure.
Raymond James.
Yeah.
The alien is gonna be dismissed.
That's 798.
Yeah, because it's 798, 799.
So the 798 carrying official appeal, so. Oh, it's 799.
799 is.
Yeah, so that one's gonna be dismissed.
Yes.
Okay.
The other one is.
The CCW is, we're gonna wait one.
Okay, wait, okay.
Is a wave?
Yeah.
Okay,
Leon,
yeah,
he was not brought over.
yes, she said it was gonna be adjourned.
Yeah. Castile,
That's not on our docket, so it was removed yesterday apparently.
we don't have to tell her that though, so she was gonna dismiss it.
I get the logic.
We don't have our people here. I was like, well, okay, sure. They'd probably cancel the Stina's, but sure. That's what you want to do.
Right,
Okay, I'm just gonna fill him in on the new stuff.
because I'm thinking if he's okay with it. I'll say final fall, if I fall, call Sam Burston, or call Lee Free, if I fall.
Mhm. Oh.
But I don't think.
Way over. Yeah.
Do you guys want to put your resolution on the record before this exam starts? Okay.
He's gotta be brought up.
Oh, that's tough. I don't know what to do then.
Oh, it doesn't bother me.
I usually try to get everybody out of here, but I don't know. We'll have to-
Okay. We've got Castile.
I think like that's on the docket.
Yeah. Benchmark status.
Yeah, that's
But if you want to
unfortunate.
dismiss it, I'm fine with that.
I mean, it's gonna get dismissed eventually.
Okay, so.
Yes, yes.
You want to see if we can get
Okay.
No,
yo,
If we.
you'll bring your guy up to get that off the way.
yeah, we
Um,
were looking at it.
So let me
Can we do that?
Yep,
I
Great.
was,
David to Jeff or Carlos. Hey, Jeff.
my good chief like finishing. No, wait.
Speaking of this plan, he has a case about licensed vaccination.
Okay.
Oh, I'll talk about it.
Today-
It's not gonna be, yeah, I can do it afterwards, you're right. I just thought about that. We could have done that after. But I'm gonna call it, I don't know why we're talking about it.
We're ready.
We're gonna get Milks in and out on his real quick, because he's just a waiver up. and then- Okay.
But I just think his client's not here.
Oh, he's
It
coming
needs
up.
to be Brought up.
Yeah, he's coming up.
Oh, okay,
Yeah.
cool. That's fine. We should be ready on, we should be able to knock it out.
Brandon James, right? No.
Yes, sir.
Thank you.
Yes, thank you. I will do it. We'll do terror, but I don't think that's statutory changes. I don't, yeah, but obviously, so, okay.
Hope this blue doesn't bother you.
I mean,
I'm just saying. It's always mentioned.
where it is, you know.
Actually, you might be beating the shit
Might be
out
good
of
for
the
you,
Blues.
might be good for me.
This is a
In the
sports
long
reference,
run.
right?
Yes.
Yeah.
Yeah, okay.
We will see.
Yeah, I don't like their swim team. Something, I assume.
Your partners, fighting since Ohio State. So-
Yeah, but it's fine.
Well, that's true. He's in the golf league.
He really is.
George's best friend. That's the
No,
best friend.
Look, I'm gonna hold back as an Ohio person against you too.
That's
You know,
George's best friend.
Yeah, you're guilty by association.
I just know the guy.
You big Ohio fan too?
Hey, Dan, the prosecutor is, he's from
Oh,
Ohio.
yeah, that's right.
Yeah.
You know what you should do is go find Judge Simmons and tell her how much New England sucks. The Patriots.
Oh,
No,
man.
she's really fun.
Oh, she like that.
She'll love that.
Yeah.
Sarah.
I
Sarah,
on,
is that on? That fan on?
yeah, Milks, do
Thank
you
you.
wanna go on Liaison as
No,
well?
Yeah, because it's gotta, it has to be an attorney. I guess.
Right, so it'll be quick. Okay.
No, it's just Mr. Steele and.
I'm not dismissing you today.
I don't mind though.
That's a good effort.
Thank you, I really. tried.
Yeah, it's a really good try.
Oh, no. I don't think that's- We just got a few ants in the office. It was clean.
That's me.
You got an email saying they have exterminated for us.
Because
He's painting roses.
the air conditioner is way louder than it should be too, because when that kicks on, I can barely hear my own thoughts. Yeah.
Man, how's Robert?
He's doing great. He's really changed out there.
Yes.
So we should. Yeah.
All rise.
You be seated. Ms. Fortuna Gill, who are we calling first?
Yes, Your Honor. Handle Brandon James or James
Brandon.
Brandon. Is that Brandon James?
He's in rock right now, Judge.
So is he in lockup?
Yeah, they're bringing him.
Oh, he's not up here yet.
Okay.
I also
Oh,
have MDOC.
So you want to start with Miss Donnelly's, that's MDOC for Heredia.
we can go on that one.
And then Mr. James is being brought up, and then Miss Wanji's here on Mr. Borkman.
This is Mr.
Brandon.
Brandon, so we got two
Brandon.
Brandons.
Oh, but you have first and last name, Brandon.
Yeah.
So this is DeQuarian Brandon. Okay. All right. All right. All right, so Ms. Donnelly, you're here with Mr. Heredia. We're on the docket in case 26-00658. That is the city of people of the state of Michigan versus Antonio Heredia. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Antonio Heredia, who is seated to my left in the jury box.
And sir, you are Antonio Heredia, is that correct?
Yes, sir.
Right, thank you. This is the time set for a preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor, I will defer to Ms. Donnelly.
Ms. Donnelly.
Your Honor, there has been an offer extended to defendant that he would like to take today. Right now I'm having him fill out the advice of rights.
All right. And what is the plea offer at this time?
Yes, Your Honor, the offer is to plea to the flee and elude fourth and the OWI, and to dismiss the possession and the habitual notice as well.
Okay, so it's plea to flee and elude fourth, and would be a plea to so it'd be a plea to count 2 and 3.
Yes, Your Honor, it would be a plea to count 2 and 3 with the dismissal of count 1.
All right. Plea to counts 2, 3.
And I do apologize, this was up in the air really till the last minute
Yeah.
here, so I don't have a completed plea sheet for you, but I can work on it right.
No, I think we can.
It was count two, if you're amending here to fourth and 10th.
Oh, I thought
Yeah.
it was a fourth already.
It's a 2-year right
Yep,
now.
that's my, so it would be an amended count 2. Thank you, Ms.
Amended
Donnelly.
count 2 of attempt to make it a 1 year.
Attempt fourth to make it.
That is correct.
So that'd be punishable by 1 year and or $1,000. And I think that's the same pack code with an A.
That is correct, Your Honor.
That's 750. 479. 1-A. So it'd be an amended count 2 and a plea to count 3.
Yes.
Which is the OWI, and that's punishable by 93 days and or 100 to 500. And then a dismissal of count 1, which is the possession of methamphetamine. Is that your understanding, Ms. Donnelly?
Yes.
And so it's my understanding that at plea to count 3, would require him to go to probation for the
Be
assessment.
referred to probation for the assessment,
Right, right.
which we, defense is comfortable with.
All right, all right, all right. So Mr. Hedia, this is, as I understand the plea offer, is to plead to an amended count 2 of an attempt, flee and elude, which is punishable by 1 year and or $1,000 pursuant to 750.479A1A, and then plead to count 3, which is the operating while intoxicated, and there'll be a dismissal of the count 1, which is the possession of methamphetamine. Is that your understanding, sir?
Yes, sir.
All right. And have I correctly indicated the nature of the plea offer, Ms. Fortuna Gill?
Yes, Your Honor.
All right. And then you have an advice of rights, Ms.
I do if I can approach.
You may. All right. So I'm in possession of the advice of rights for 12 advice of rights, and you've signed the bottom of this. Is that correct, sir?
Yes, sir.
All right. All right. So I'll hit the highlights concerning your misdemeanor rights. You understand, sir, that you're to be tried by, you have the following jury trial rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. Do you understand that?
Yes, sir.
If your plea is accepted, you'll give up the claim the plea results of any promises other than what we've stated on the record or threats. It was not your choice to plead guilty. You'll also be giving up the right to appeal anything from trial. Since you won't be having a trial today, you'll be pleading guilty to the attempt, flee, and elude, and the operating while intoxicated. Is it still your wish today to waive your jury trial rights and plead guilty to the amended count 2 and count 3, which is the attempt, flee, and elude, and the operating while intoxicated?
Yes, sir.
All right. Again, you raise your right hand as best you can. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to bring your attention back to February 2nd, 2024. Were you operating a motor vehicle open to the general public on South Waverly Road, Glenburn Boulevard in the city of Lansing?
Yes, sir.
Okay. And we'll start with the attempt for, were you given a visual or audible sign to pull over by law enforcement?
Yes, sir.
And you knew they were law enforcement at the time?
Yes, sir.
And you refused to pull over at the time?
Yes, sir.
Okay. Anything towards the amended count 2 of an attempt, flee, and elude, Ms. Donnelly?
No, Your Honor.
Ms. Fortuna Gill?
No, Your Honor, the people are satisfied.
All right. In count 3, were you operating a motor vehicle open to the general public on the city of Lansing, South Waverly and Glenburn Boulevard on February 2nd, 2024?
Yes, sir.
Okay. And at some time prior to the event or after the event, but do you learn you were operating the motor vehicle with a blood alcohol level of over 0.08 grams?
Yes, sir.
Okay. And so so for our purposes, you don't dispute that per blood you came back at 0.133. Okay. Anything towards a factual basis, Ms. Donnelly?
No.
Ms. Fortuna Gill?
No, Your Honor.
All right, I find the factual basis to be knowing voluntarily and voluntarily giving, knowing accurately voluntarily given. And I'm going to place the advice of rights in the file. I don't know how it works, the probation. I don't know if they come out to see you or if you're seen. Ms. Donnelly, do you have any concerning, because they're gonna want to do an assessment.
Exactly, Your
Yeah.
Honor. I'm not sure how they.
All right. So probation will most likely be to see you just doing an assessment because it's statutorily, they have to do it. And then we'll set the sentencing date. So you referred to probation for the PSI and for the assessment. And then we'll do the sentencing date 6 weeks out.
Okay.
So
May 29th.
May 29th at 9:30. So
Oh, sorry, was that a?
May 29th at 9:30. So if you're still incarcerated, we'll writ you out for the May 29th date. If you're not incarcerated at that time, Then we'll see on May 29th at 9:30. All right, sir?
Yes, sir.
All right. Anything else for the record in docket 26-00658, Ms. Fortuna Gill?
No, Your Honor, thank you.
Ms. Donnelly?
No, thank you.
All right. We'll see you on May 29th at 9:30. You should be all set. Thank you. Thank you for your assistance today.
Thank you, Your Honor.
All right. All right, Ms. Fortuna Gill, where did you want to go next?
Brandon James, Your Honor.
All right, so we have, that's Ms. Maycomer and Mr. Milks.
Yes, Your Honor.
Just gonna trade some seats here. Your Honor.
All right. Right, so let's call those separately, okay? Just because I know we're gonna treat it. So we're on the record in 26-00798. That is people of the state of Michigan versus Brandon James. That is the CCW and looks like a R&O. Appearances for the record, Ms. Maycomer.
Good morning, Your Honor. Natalie Maycomer on behalf of the people.
Mr. Milks.
Good morning, Your Honor. Stephen Milks on behalf of Mr. James. Mr. James is present and standing up to my right here.
All right, and sir, you are Brandon James, is that correct? All right, thank you. This is the time set on this file, 26-00798 for a preliminary examination. Ms. Maycomer, how are we proceeding?
Thank you, Your Honor. It's my understanding that both the people and defense will be waiving their right to hold a preliminary examination in this matter. We'd ask that the case be bound over and the charges in the complaint. I will say that Mr. Milks and I are in negotiation discussions. Those will continue in circuit court.
And is that a fair statement, Mr. Milks?
It is a fair statement, Your Honor. It is unconditional, but I would like to address bond again, not conditioned on this waiver, Your Honor.
All right, so let me, so may I inquire of your client of his waiver of the preliminary examination on file 26-00798?
Yes, sir. Thank you.
All right. All right, Mr. James, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You're represented today by Attorney Stephen Milks, and he would be present to cross-examine any witness or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case continue to circuit court where negotiations are continuing between Mr. Milks and Ms. Maycomer. Is it your wish today to waive your right to a preliminary examination?
Yes, sir.
Ms. Maycomer, you indicated people also waive their right to a preliminary examination.
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And so on 26-00798, I'll provide the paperwork for bind over purposes to David, and then allow you to sign those. I think that's right. Thank you, David.
You're welcome.
And then prior to sentencing, we'll address bond, and I'll give you the opportunity to speak to bond.
Thank you very much, Your Honor.
All right, I'm in possession of the bind over documentation on 26-00798. It's signed by all the parties. I'm going to indicate that the examination was waived on today's date, which is April 16th, 2026. Prior to signing it, Mr. Milks, would you like to be heard on bond?
If I may, and thank you, Your Honor. Your Honor, at this time, my client's current bond in this matter, I believe, is $100,000 cash surety. We will note, as the court may also realize, he has another pending matter, 799 FY, where I believe it's a $750,000 cash surety. I anticipate, without putting any words in the prosecutor's mouth, that matter is going to be dismissed. Just so the court's aware. In this matter, 798 FY, we are requesting a $10,000 10% bond. Your Honor, I do not believe that my client is a flight risk. He's never failed to appear for court in the past, and he does have strong ties to the community. Especially recently, Your Honor, he's got a new 2-week-old that he wants to care for and obviously be around. He has every interest to avoid any additional trouble in that sense, Your Honor. So I do not believe that he's going to be any sort of flight risk. And again, as we've discussed already on the record, there are ongoing negotiations, and he does have a strong interest in completing that matter. I believe any sort of public concerns the court may have can easily be mitigated, Your Honor. First and foremost, $1,000 is a significant amount to him. It's something that he can afford, but not something that he can afford to lose. So it will ensure ongoing compliance, Your Honor. Additionally, Your Honor, with a brand new child, that's going to be a lot of work to be around to assist the mother in this matter. I really think he's going to be too tired to be too stupid. And so I think that's going to provide some mitigation there, Your Honor. And I think something like a GPS tether or other conditions the court may deem necessary, Your Honor, I believe we make it appropriate in the CCW case with maximum penalty of 5 years. And unless there's any questions, Your Honor, thank you.
All right, Ms. McComber, a response from the people.
Thank you, Your Honor. Your Honor, I will note that I believe one of the reasons that the bond is so high in this particular file is because of the secondary file, which Mr. Mills is correct, people will be asking the court to dismiss today. The allegations in this case, Your Honor, while there was an initial call about potential threats being made, there's nothing to indicate, at least that we haven't, and proof-wise, that this defendant was using the firearm in this case to threaten anyone. I will note for the court that the defendant was previously on probation, but that probation had resolved itself just prior to this case happening. So because of that, I'd ask the court to consider a GPS tether. As far as any bond amount, I think that's the court's discretion. We have no objection to the court lowering bond.
All right, so this is a request to modify bond to 10,010%. Is that correct?
That's correct, Your Honor, yes.
All right, so I'm going to grant the motion to modify bond at 10,010%. This will come with a GPS ordered, so it'll be I think it's victim notification or zone notification, whichever is preferable by the private entity. There is a no contact order in regards to Armando Pellegrino and Douglas Hall.
Those are the officers, Your Honor?
Yeah, that's the officers. So it's not so I don't know if that's a typical no contact order.
It's not, and now that the court is saying this out loud, I do know that JSG cannot do a GPS without a victim or zone notification. I don't know that there would be one that's appropriate.
If they did a zone, they'd probably do it on
the home that he lives in.
Yeah, and that doesn't seem to.
We do it for Juneau, Alaska.
What?
Yeah, I guess
we could, but I don't think that would suffice.
That's fair.
We could do it for purposes of knowing where Mr. James is at all times. So that would be that would keep him out of a zone notification, but that would let them know that if it's because I don't see the reason for the no contact order by the magistrate, since he doesn't have any control over the any further investigations, I would think. So I mean, they're gonna go to respond where they're going to respond.
And actually, maybe approach briefly, Your Honor.
Yeah.
Thank you. Yeah, I didn't really.
She's got a no contract on this too. Okay. That's how you learn.
Yeah, that's fair.
All right. All right. So we'll do the 10,010% with no GPS. Right. Yeah, you don't want to know contact.
Right. Yeah, that's right. Thank you, Your Honor.
All right.
All right.
thank you.
All right. So let's do we'll modify bond to 10,010%. We'll do a no GPS at this time, and we'll remove the no contact order. Mr. James, keep in contact with your attorney, Mr. Milks, and he'll tell you how this proceeds. But I've modified the bond to 10,010%. based on some representations of argument concerning that matter, we're not going to order a GPS tether. And then the magistrate had put no contact with the arresting officers, and we're going to remove that, okay? Because you have very little control over that. Yeah. Anything else for the record in 26-00798, this case? So you're done in district court. You're off to circuit court, where you get your next date to appear from Mr. Milks. All right, sir. Anything else for the record in 26-00798, Ms. McComber?
No, Your Honor, thank you.
Mr. Milks?
No, thank you, sir.
All right. I'm going to sign this now. 2026. And then we'll call the next case. So your time in district court is done. You're off to circuit court, okay? All right. So we're all set on file 26-00799. And then we're on the record in docket.
That's reversed.
Oh, we're on that was 26-00798. And we're on the record in 26-00799. Appearances for the record, Ms. McComber.
Thank you, Your Honor. Natalie Maycomber on behalf of the people.
Mr. Milks.
And good morning, Your Honor. Stephen Milks on behalf of Mr. James. Mr. James is present, staying to my right at this time.
And then once again, sir, you are Brandon James. Is that correct?
Yes, Your Honor.
All right, thank you. This is time set for a preliminary examination today on 26-00799. Ms. Maycomber, how are we proceeding?
Thank you, Your Honor. Your Honor, I'm preparing for this preliminary examination, both last night and then with the detective this morning. It came to light that the people are not able to proceed in this file. We'd be asking the court to dismiss this file because we are unable to proceed. We will not be asking the court to reissue this case.
All right, and Mr. Milks, I'm assuming you have no objection to the dismissal without prejudice.
That's
okay. Okay, so based on the prosecutor's nollie pros to dismiss, I will grant that, and then can we,
So the prosecutor.
yeah, let's.
Natalie, what's your P number?
80008.
So dismissal with the without prejudice, Mr. James, means that people could reissue if they choose to. They've indicated they're not going to reissue on this file. And so I'm going to sign off on the nollie pros or dismissal without prejudice, just so you know, okay, sir?
Yes, sir.
I do have a GPS and a no contact order. So you should, if you're able to make bond, you should probably carry the dismissal around with you. It takes about 4 hours to purge from the computer system.
Okay.
All right. So we'll grant the dismissal without prejudice on docket 26-00799. And I'll sign the dismissal without prejudice. You can get a copy, Mr. Milks, you probably want a copy for your court office, and we'll give you an extra copy to carry with you. If you're able to make bond, then you should carry this on your person, at least for today's purposes. Anything else for the record in docket 26-00799, Ms. Maycomber?
No, Your Honor.
Mr. Milks?
No, nothing from the defense. Thank you, sir.
All right, you should be all set, Mr. James. My court officer will give Mr. Milks and yourself a copy, all right? You're all set, Ms. Maycomber?
Yes,
That
sir.
was your one file?
That was it.
That was your two files, I should say.
That was.
Leah, huh? With you.
Right, no, he's not here.
Right.
Right.
So do we want to put that on
Yes,
the
no,
record?
Yeah, you want to put Mr. Leha?
So you can leave?
Yes, that'd be great.
All right, so this is the time set on 26-00848 for People of the State of Michigan versus David Ortega Leha. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Milks.
And good morning again, Your Honor. Stephen Milks on behalf of Mr. Leha. Mr. Leha is not here at this time. I went down to go speak with him today. Apparently, he was not brought over from ICJ.
Yeah, and that's my understanding is that Mr. Leha, and Mr. Leha was previously here and incarcerated last week. And then for bond violation and so there's some question as to whether this is going to end up in other charges or so at this time, the request would be, and Mr. Leah is obviously not here because he hasn't been brought over. So the request would be to adjourn this, a good cause adjournment, to see what the status of the case is. Is that a fair statement, Ms. Fortunigo?
That is my understanding, Your Honor. Just for the record, I did have the complaining witness present today, but I explained the situation to her and have since let her go.
Yeah, I don't know why he was not brought over, but we will find a good cause adjournment. And we will reset the matter. We can probably just reset for prelim, or did you want it to reset for probable cause too?
I prefer prelim.
The prelim, okay, reset for prelim. And that would be probably sometime after next week. So it'd probably be in May.
Yeah, I would need 14 days.
Yeah, so let's see. To be after 14 days.
Yeah.
For subpoena purposes. Yeah. And so it can be that Thursday or Friday sometime in May. Okay.
What time?
May 8th at what time? At 8:30. All right, we will reset for May 8th at 8:30. I know Mr. Leah is incarcerated because he was on a probation violation. And I think we set that around that second week of May. So if not later.
And Your Honor, correct me if I'm wrong, I believe he's got a sentencing coming up with Mr. Harris from our office. I believe it's before Your Honor. I think I've got something written for May 18th.
That sounds right. That could be the sentencing on what he pled to previously. So I know he'll be incarcerated on the date that we read him out. So we will have to bring him over. Maybe this time they will bring him over. Okay, you know, because he will be Leha, because he will be on, and we put him on the list. They it just happened. So all right, so we've set it for May 8th at 8:30 for continued preliminary examination. And it is not continued preliminary examination because we haven't started the preliminary examination. Anything else for the record in 26-00848, Ms. Fortuna Gill?
Not for the people.
Mr. Milks?
No, nothing further. Thanks, sir.
Okay, you should be all set. Thank you for your appearance today.
Yes. See.
So who did you want to go on next?
If we could get the waiver on C
On
on the
Joseph
record
C?
before we get this exam rolling.
All right.
I will be able to let about 10 police officers leave.
All right. All right, so we're on the record in docket 26-00849. That is people of the state of Michigan versus Joseph C. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Joseph C., who is standing to my right.
And sir, you are Joseph C., is that correct?
Yes, sir.
All right, thank you. This time set for a preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. It is my understanding that the defendant wishes to waive the right to the preliminary examination. The people would be willing to do the same.
And negotiations are continuing?
That is correct, Your Honor. There's no offer to put on the record, but negotiations will continue in circuit court.
And is that your understanding, Ms. Donnelly?
Yes.
All right. May I inquire of your client of his waiver of the preliminary examination?
Yes.
All right, Mr. C, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Sarah Donnelly, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to a preliminary examination, have this case continue to circuit court where negotiations are continuing between Ms. Donnelly and the people of the state of Michigan. Is it your wish today to waive your right to a preliminary examination today?
Yes, sir.
Ms. Fortuna Gill, as previously indicated, do the people also waive their right to a preliminary examination?
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made, and I'll provide the bind over documentation for signature purposes to David. Thank you, David. Thank you, Josh. All right, I'm in possession of the bind over, thank you, David, on docket 26000849, signed by all the parties. I will sign the document that the examination has been waived on April 16th, 2026. Bond was previously set by the magistrate. Anything else to come to the court's attention before I sign the bind over documentation, Ms. Fortuna Gill?
Not for the people.
Ms. Donnelly.
Not for defense.
All right, I will sign the bind over documentation. So, Mr. C, your time in district court is done. You're off to circuit court, where you'll get your next date of appearance from your attorney, Ms. Donnelly. All right, sir?
All right.
All right. You should be all set, sir. Thank you for your appearance today.
All right, we are ready on the exam, Your Honor.
For this is Aquarian Brandon. Okay.
I do have two witnesses present in the courtroom, so they would need to be sequestered.
All right, so we're on the record in docket 2503183, appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Wanji.
Good morning, Your Honor. I am to want you for Mr. Brandon, who's sitting at the council table.
And sir, you are DeQuarian Brandon, is that correct?
Yes, sir.
All right, thank you. This is the time set for preliminary examinations. My understanding, the preliminary examination is going to run. So I will, so first of all, if any witnesses who is going to watch another witness testify has to leave the courtroom. So I'll invoke the sequestration order at this time. And then Ms. Fortuna Gill and Ms. Wanji probably know the case better than I do. So if they see anybody that they expect to or anticipate would be a witness, we'll just move them out of the courtroom. So. All right, and is there any other matters to come to the court's attention before we start the preliminary examination, Ms. Fortuna Gill?
No, Your Honor, and sorry about that.
Okay, no worries. Ms. Wanji.
No, Your Honor, thank you.
All right. So the people may call their first witness in the preliminary examination, people of the state of Michigan versus DeQuarian Brandon.
Thank you, Your Honor. Do people call Greg Darling? And I'll have to go chase down David.
All right.
Well, they need Greg.
David, can you get Greg Darling a witness? Greg Darling.
Oh, Jeez.
Still waiting for him. Sure did.
Locked in. Yeah.
Who knows?
Sorry about that.
All right, Mr. Darling, you can come up here. We're gonna have you stand in front of me and spell and state your first name and last name for the record.
Gregory, Gregory, Darling, Darling.
Please raise your right hand, sir. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth on the penalty of perjury? All right, go ahead and have a seat. The microphone goes right to the court recorder's ears, so please project as best you can.
Sure.
All right, Ms. Fortuna, go when you're ready.
Yes, thank you. Good morning, Mr. Darling. Thank you so much for being here. I know you have been here multiple times before and have been here all morning, so I appreciate it. I just have some questions for you, and I just ask that you answer as truthfully as you can. I don't know and I don't remember are perfectly acceptable answers. We just want to find out what you do know and what you do remember. First, can you tell me what you do for a living?
I'm plant manager of American Rheumatology.
Okay, and what's the address of that location?
1600 North Lark Street, Lansing.
Okay, and that's in the state of Michigan,
Yes.
county of Ingham? Okay. And do you recall anything particularly noteworthy occurring on February 10th of 2025?
What day?
Of the week?
Yes.
Well, that is a great question. I can find out for you. This is a Monday. February 10th of 2025 is a Monday, or was a Monday.
Yes.
Do you recall that particular Monday in question?
Yes, I do.
Okay. Can you tell me what's so noteworthy about that day?
Yes, it was reported to me the morning when I arrived that one of our material handler vehicles, a tugger, was parked in front of the building.
Okay, and
Extremely odd.
okay, I was gonna say, can you explain to me why that's out of the ordinary?
Yeah, it belongs in the shop, not on the sidewalk in front of the shop.
Okay, do you know why that truck and it was in front of the?
After some investigation and watching some video, we determined that someone had stolen some items, several $1,000s worth of items from the plant. Apparently loaded those into that vehicle and drove around to the front of the plant.
Okay, and is that something you saw for yourself on video footage?
We had some video of that.
Okay. And you asked what day of the week February 10th was. Can you tell me why? Why is that significant? What day of the week it was to you?
Well, I wanted to make sure that I understood the question, and I don't recall the actual day. The date is significant to me of the theft that was the person in question who did this, stole from the plant, was terminated on a Friday.
Okay.
Or one was terminated, sorry.
So that would be Friday the 7th.
Yes, I think so.
And do you recall at all why that person was terminated?
I don't exactly, I believe it was performance based.
Okay. No, that's okay. Also, what else did you see in the video footage?
Saw a man inside our tool crib or MRO crib, if that makes sense. It's where we store all of our items that we use to work in the shop. Saw a person in there going through cabinets. Appeared the person that was in there had a lot of knowledge on what was in there. I'll say that. So they understood exactly where to go, what to take, very specific tools of the trade of welding.
Okay. And forgive my ignorance, can you further explain what a tool crib is? Is that a room where you keep things, or is it a box?
It's a caged area.
Okay.
So it's a caged area inside my plant. There's a locked area.
Do you know how this person in question got into the locked area?
I believe they climbed over the fence.
Okay. And that's again something you saw on video?
I don't think I saw the actual act of that,
Okay.
but with the door being locked, that's a presumption.
Yeah,
Okay.
okay, Your Honor, I will object for speculation.
So that I understand that's part of the opinion here, that he's indicating the door was locked. So that's one way you could enter in. But the objection that it calls for speculation on some level.
Understood.
Okay, so with that understanding, the objection is sustained. Although it is the opinion of the witness, there's only so many ways to get into the cage. You may proceed, Ms. Fortuna Gill. The objection is sustained.
Thank you. Okay, did this person do anything else that you saw?
Yes, we did not see the act, but we saw evidence of two large video monitors that were broken
Okay.
and two computer monitors that were broken as well. Those were broken in very specific areas related to welding, the welding supervisor. So it would appear again, this person knew exactly where to go, cause the damage and steal.
Okay, and the approximately, if you know, how much were the damages in totality?
Believe that I don't have it on me. It exceeded $12,000 to my recollection.
Okay, and did that include the damages and what was stolen?
Yes.
Okay, are you able to at least approximate it for me in what was stolen and what was damaged?
Yes, there was the two video monitors and two computer monitors. You as far as the cost of those?
Approximately, yes.
That was probably around $1,500. And again,
Okay.
that's
Sure.
a speculation, and I don't have the.
Well, if it's speculation, Your Honor, I would object.
With the understanding, is that per monitor, the $1,500, or is
No,
that?
that would
that'd be all
totality.
together.
Now, I did provide an Excel spreadsheet to the authorities at the time.
Yes.
I just don't have that on.
All right.
I didn't think to bring that.
All right, with the understanding that it's kind of an eyeball. It's kind of a.
Yes, Your Honor, if I may respond, I
You
would
may.
say I don't believe that it's necessarily speculation in this case. Mr. Darling knows what the damages are very close. He maybe just doesn't have an exact number. He did prepare a spreadsheet.
All right.
And provide that to authorities.
And with the understanding, the witness did indicate he's speculating, but that's what spawned the objection.
Yes, I
but
understand.
but it is a ballpark figure of over $1,000 is what
Yes.
he's indicated damages were. In regards to, and then in regards to what was stolen, what is that amount? And you asked that question.
Yes, but I did ask it in a compound way, so I have no problem asking it again. Do you know how much was stolen?
The dollar amount was exceeding $12,000.
Okay. So you know for certain that what was stolen exceeds $12,000? Okay, and you know for certain that what was damaged at least exceeds $1,000?
Yes.
Okay, thank you. And can you do you recall the name of the individual who was terminated?
Yes.
Okay, what is his name?
Aquarian Brandon.
Okay, and do you see him here today?
I do.
Can you point him out by describing the article of clothing he's wearing for me?
Wearing orange, sitting right to the south, I guess, for of the defense attorney.
Thank you. Your Honor, at this time, I would like the record to reflect that the witness, Mr. Darling, has identified the defendant as DeQuarian Brandon.
Okay, so in the courtroom, the witness has identified the defendant as DeQuarian Brandon, but I don't have anything indicating at the scene.
Understood.
All right. So any objection to the defendant, to the witness identifying the defendant for purposes of prelim as the person sitting next to you?
As long as we know that he's identifying the person that was fired.
Correct, correct. And who's sitting next to you as
Yes.
Mr. Brandon? All right. All right, with that understanding, the witness has identified the defendant for purposes of prelim. You may continue, Ms. Fortuna Gill.
Thank you, Your Honor. Can you tell me, Mr. Darling, what it is that leads you to believe that Mr. Brandon was the individual you saw on that video?
Sure. Because of the scenario of Mr. Brandon being terminated, led us to believe that he was the one that stole from the company. Also looking at the specific items that Mr. Brandon took from the plant, very specific.
I would
welding
object to
tools.
Mr. Brandon took
To, well,
because,
yeah, so the individual who was seen on the video,
thank you.
okay, that's a reference point, yeah.
Yes, I understand. I would just ask that we give the witness an opportunity to explain why it is
Right.
he believes that could be Mr.
So
Brandon.
with that understanding, the witness can continue. I'm going to sustain the objection as to, because we don't know who was on the videotape at this point. There's an inference being made, and the witness can continue with the inference.
Thank you, Your Honor. You can continue, Mr. Darling.
So based on the scenario, like I said, when this employee was terminated, and then when the discovery of the items that were stolen, and with the somewhat limited video that we had, matched some of the description, I would think, of the defendant.
Okay.
Longer hair, kind of a braided. It's,
So there's longer braided hair.
yes.
And when you saw Mr. Brandon on Friday, did he have longer braided hair?
Yes.
Okay, and that matched the individual in the video who also had longer braided hair?
Yes.
Okay. Was there anything else about the individual in the video that matched Mr. Brandon's description?
I can't say for sure.
Okay. And then I do have one more question. You had mentioned that the screens, the monitors that were damaged were in the welding area. Did Mr. Brandon work as a welder or in the welding? Okay.
He was a welder. The one of the video screens was in the weld school where he was trained, so he was familiar with that area. And as I recount, the video screens, the computer monitors were at the desk of the weld instructor, the weld trainer, and also the weld supervisor. Again, very specific areas.
Okay. Do you recall if anybody else was terminated that Friday?
I do not recall.
Okay. Can I also ask, our welders, I would assume, but our welders, did they have regular access to the tool crib?
The access to the tool crib is restricted. So there's either a tool attendant there to
Okay,
do that, or they can be let in by a supervisor or team. So it is a restricted access.
understood. In the day-to-day, as a welder at your plant, would welders frequent the tool crib under those restrictions?
Yes, if they needed supplies, they would go there and gain access through means of a supervisor or team.
Okay, so is it fair to say that someone who's a welder at your plant would know what was in the tool crib?
Yes.
Okay. And then, sorry to go back, I wanted to hear a little bit more about the truck that you indicated was in front of the plant. And
Yes.
is the truck something that welders have regular access to?
Some do.
Okay.
I personally saw Mr. Brandon drive that truck while he was employed there.
Okay, that exact same truck?
Yes, we only have one like that.
Oh, okay, thank you for the clarification. Okay, I have no further questions for this witness at this time.
All right, thank you. Cross-examination, Ms. Swanson.
Thank you. Good morning, sir. Do you know the job description of Mr. Brandon?
I'm
His
sorry,
job description.
job description.
What was his job description?
Yes, he was a welder.
Okay. And you testified that to have access to the area where things were stolen, allegedly stolen, you have to have an instructor or someone giving you access, correct?
Yes, there is restricted access to that.
From Mr. Brandon's job description, he need someone to bring him there.
Yes.
Were you there when he was terminated?
On Friday the 17th.
Mhm.
Yes, I was in the plant.
Were you present or during the termination?
I do not believe I was present during his termination.
And what is usually the process of terminating an employee? Do you know, if you know?
Yes, the employee is typically brought up to the HR office by their supervisor or maybe by the ops manager. And they have a meeting in the Human Resource Department and to discuss the termination and then execute the termination.
And to the best of your knowledge, when there is a termination, everything that belongs to the company is returned, correct?
That is the case in most cases, yes.
Okay. And do you know if Mr. Brandon returned his the company's belongings?
I'm not certain of that.
The truck that you said was parked in front of the building, was it does that truck belong to the company?
Yes.
And to be able to drive that truck, you have to have permission. Is that correct?
Yes.
You describe, so I take it from your testimony that the video was not a good video. It was poor quality. Is that correct?
I don't think I said poor quality.
I'm just asking you whether or not.
The video we had was adequate quality.
Okay, but you could not see the face of the person on the video.
Correct. It was obscured, covered.
Okay, cover with what?
Like a gator, you know, that like a winter face covering type of thing. That's what it looked like. You know, we call them a gator.
Okay,
Welders wear them as well.
okay.
For protection from the light and things like from the flash of the weld. Sorry.
How long, if you know, had Mr. Brandon been working at your plant?
To the best of my recollection, Mr. Brandon was hired as a temporary, I believe around September of that year. And then was moved into a permanent status in January of 25, I think, yes.
You were not his supervisor.
Not his direct supervisor.
Okay. How often do you had contact with him? Have you ever had contact with him?
I think a few times, not an extensive amount of contact, but a few times. I
Okay.
mean, we referred to Mr. Brandon as DQ. Everybody did.
Okay.
So I knew of him fairly well. I'll say that.
Your plant has some contract with the federal government. Is that correct?
Yes.
And so it's a secure plant.
Yes.
And to have access to some areas, you have to have the permission, or you have to have permission to have access to those places.
Correct.
We already established that Mr. Brandon, or I don't know if I asked you, did you know if Mr. Brandon had permission to be in those areas? Did he had access to be on those areas without a supervisor?
In which area? I'm sorry.
The area where there was the tools were stolen.
He did not have access to open the tool crib.
Okay.
Okay. Where, like I said before, a supervisor or lead would have to open that for him.
Okay.
And that was during the course of his employment?
Yes.
Okay.
How many people, the instructor, the welding instructor, how many people he instruct per day or let's say per week?
The instruction happens on an as needed basis.
Okay.
We may have 8 to 10 welders being instructed at one time. Typically groups are that large, maybe a little bit smaller, but it's not on an everyday basis. Okay.
Okay.
If I may elaborate, is that okay?
Yeah.
Once a welder is trained and certified, then they start reporting to their welding supervisor.
Okay.
Is that?
And do you know how many people the supervisor supervised at the time that Mr. Brandon was let go or was working at your place?
Approximately 30
30
welders.
people? Who was the direct supervisor for Mr. Brandon? Yes.
His name was Eric with a C, Zagata.
How do you spell the name, please?
Zataga. Maybe I spelled that wrong. Zaga. See it all right, so apologize.
That's okay. there was, when you were told about the incident, did you know, was anything, you don't know how the person had access to the building, correct? You don't know for sure.
Correct.
Nothing was broken into. Was there any forced entry that you observed?
I did not observe the forced entry.
I have no further questions, Your Honor.
Redirect Ms. Fortuna Gill.
I have no further questions, Your Honor.
May this witness be excused from the people,
Yes.
from the defense?
Yes, Your Honor.
Sir, thank you for your appearance. You're all set. Any further witnesses from the people, Ms. Fortuna Gill?
Yes, Your Honor. The people will be calling Becca Spada.
Okay.
You may go. Oh, no, no worries.
All right, Ms. Spada, you can come up here. I'm gonna have you stand right in front of me and please state and spell your first name and last name for the record.
Rebecca Spada-Gashesky, Rebecca Gasieski.
One more
Right.
time slower.
Oh, yeah, sorry. I thought you, okay. Rebecca, Rebecca Spada-Gashesky, SP as in Paul, Ada Gasieski.
Please raise your right hand, ma'am. Do you solemnly swear from tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Right, you can have a seat. The microphone doesn't amplify the voice. It goes right to the court recorder. So please project as best you can.
Okay.
And Ms. Fortuna Gill, when you're ready.
Thank you, Your Honor. Okay, can you tell me what it is you do for a living?
HR manager,
Okay, and where at?
American Rhinemetall.
Okay. And is that address 1600 North Larch Street?
Yes,
Okay. And that's in the city of Lansing,
yes,
state of Michigan,
yes,
county of Ingham.
yes.
Okay. And were you working in your capacity as an HR manager on February 10th of 2025?
Yes,
Okay, and do you recall anything particularly noteworthy about that day? Monday, February 10th, 2025.
Monday, February 10th.
Yes.
Oh, around February, right?
Okay.
We're in February.
Sure.
As I recall, it was a Friday, but maybe Monday. As far as this DeQuarian goes, we did address DeQuarian's performance and release him from employment.
Okay, so that would be February 10th would be the date that
Yes.
LPD was contacted.
That is
February
correct.
7th is the date. that-
Okay,
Yeah.
okay,
But in February,
okay.
that's okay. No, that's totally fine. We definitely want you to just testify to what you remember and what the truth is. So if you don't remember and dates are hard, but in February,
Yes,
you recall having addressing Mr. Brandon's performance.
correct.
Okay, can you tell me about that?
What I can tell you, yes.
Yes.
Kind of an overall, like we do any other employee, so addressed performance, which led to dismissal of employment.
Okay. And you said you recall that being on a Friday.
Yes,
Okay, Friday in February of last year.
yes, 2025.
Okay, and do you recall anything noteworthy happening after the dismissal of Mr. Brandon?
In person, no. The dismissal day was completely normal,
Okay,
fine, nothing noteworthy there.
did anything happen later on?
Yes, so after, well, on that Sunday night, actually Monday morning, I received information from my team leads and supervisors that there was a destruction of property, specifically a TV screen in our weld school, a supervisor's computer screen shattered, and then potentially items stolen.
Okay, and can you tell me, if you recall, what Mr. Brandon's role was?
Welder.
Okay, and can you tell me, where the screens were located that were damaged, if you know?
Yeah, so one for sure was the supervisor office. The screen that was shattered was the supervisor that was involved in Mr. Brandon's dismissal.
Okay. And did you see any of this damage yourself?
Yes.
Okay, can you tell me a bit about that?
Oh gosh, I'm not an expert on what shattered.
That's okay.
But the weld school TV is really what I saw in person.
Okay.
By the time I was at work, the monitors were already replaced or gone out of my sight. And shattered, kind of just like if my kid threw a ball and shattered the TV.
Sure. Perfect. That is great. Thank you. And then my other question is, did you watch any video footage related to this incident?
Yes.
Okay, can you tell me what it is that you saw on the video footage?
Video footage that I saw was in our tool crib, where, a person was going through the tool crib and checking things out, grabbing various items.
Okay.
I couldn't confirm from the video what items those were, more so because I'm not well versed in our tools specifically.
Perfect. I had to have a definition of tool crib given to me earlier, so understood. Was there anything particularly recognizable about the individual on the video? Anything about their looks or gait, anything like that?
It has to be open-ended question.
That seemed fairly open-ended, but you can rephrase if you want. So the objection sustained and you can rephrase.
Sure. I Was there anything particularly recognizable or distinguishable about the individual on the video to you?
First off, it was hard because there was a face covering and hand coverings.
Sure.
Okay. So overall, anything very distinct, I believe, potentially hair. And then, and this may not mean anything, but kind of overall demeanor or walking, kind of the way this individual walked. Outside
Okay.
of that, no.
Okay, tell me a bit more about how the individual walked. Did that remind you of anyone in particular, or was it just a?
John, again, open-ended questions.
I'm gonna allow you to,
Question.
it seems open-ended, but you can rephrase the objections the same.
Thank you. What about that person's gait that you described was noteworthy to you?
So first off, imagine I'm watching this video, you know, thinking of who could it be, what events have happened, right? So an event of a dismissal had happened. That's always the first thought in my mind, right? Because that's our, as HR, that's kind of what we look at.
Can I have a follow-up question here?
Yes.
Was anyone else dismissed that Friday? No. Okay. So there were no other dismissals that Friday?
No.
Okay, thank you. Now, if you could proceed telling me a bit about how you identified the individual on the video.
Well, again, I couldn't specifically identify, but the person, just based on overall demeanor, looked like Mr. Brandon, who we had dismissed.
Okay, and is there anything particular about the demeanor that you can point out to me? I know that's a little tricky.
Yeah, it's kind of hard to describe. And if I'm remembering back, I think it's a little bit of a slower, more casual walk, kind of like a hard to describe, but
that's helpful. And then you mentioned hair. What about the hair specifically?
If I'm remembering correctly, there were dreads.
Okay, was the hair short, medium, long?
Long.
Okay, so longer braided hair. Okay.
Is that a yes, ma'am?
Oh.
Is that a yes?
Yes.
Okay, thank
Yes.
you.
Sorry, I didn't give you the spiel about responses needing
Okay.
to be typable.
Okay.
So no head nods or mhm. Anyway, okay, was there I sort of cut you off, so was there anything else identifiable in the video? Besides, if you mentioned the longer braided hair and the slower, more casual gait.
The only other thing that was pretty evident to us was that whoever did this knew where things were, right? Which led us to believe that they would be an employee with us or a previous employee, because they knew where to get the keys to go into the crib. They knew where the keys to one of our little industrial vehicles were to then drive it out of the building. So
okay,
that's the only other thing.
and then I know I asked you if anyone else was terminated on that Friday. Was anyone else terminated that previous week that you recall?
Probably. It's usually every week that somebody's terminated,
Sure.
so probably.
Okay, but just not that Friday.
Yeah.
Okay. Okay, I have no further questions for this witness at this.
So cross-examination, Ms. Swansea.
Thank you. Good morning.
Morning.
Did you do the termination?
Yes.
And will you explain to the court what is the process that you went through that day when you were terminating Mr. Brandon?
So if I'm remembering correctly, we had pulled Mr. Brandon in to the HR office, sat him down and spoke with him about performance and let him know that we were separated.
Okay. And when you did that, he had to give you back the belongings that everything that does not belong,
Yeah.
things that belong to the
Yeah.
Okay, so he turned his badge.
So the badge, I don't believe we got. However, in those kind of instances, we would contact IT and they would deactivate the badge.
Okay, so he will not be able to use the badge anymore.
Right.
And did you deactivated his badge before he came or after he was dismissed? Before. So he would have not had any way to access to enter the plant unless he was let in, okay?
Any badge access doors, that's correct.
Okay.
Yeah.
And to go to the HR office, do you have to use a badge access door?
Mhm. Yes.
And to go to the tool crib area, do you have to have a door access, go to a door access badge?
So I believe that the tool crib is accessed through a key and lock versus a swipe of a card.
Okay.
Which is why certain people have keys or we place keys.
Okay. In places. And to your best of your knowledge, when Mr. Brandon was let go, he didn't have the key.
No. Those keys we don't, those are only should be only accessible to supervisors.
Okay. And during his employment, he would have not had the keys.
No.
And what level of you have? I know that he was you have different level of employees.
Mm-hmm.
Would
Yes,
you?
no.
Yes.
Okay.
So to the best of my knowledge, he was not the employee whose level would allow him to have a key.
Correct.
He was not the kind of employee that would have access to the tool crib without a supervisor.
Correct.
If the termination was done properly, after he left, he would have not been able to enter the building.
Correct.
Through the access.
Through the access doors, correct.
And
through with the badge swiping specifically.
Okay. And for example, guests, when they come to the inside the building, do they have a specific area where they are kept?
They have to be escorted.
They have to be escorted. And after his termination, for Mr. Brandon to come to that place, he had to be escorted.
Yeah, if he was to come knowingly, yes, he would have been escorted.
Okay. How often do you have contact with Mr. Brandon?
When he was an employee?
Yes.
Kind of just an as needed basis, maybe whenever, okay, so him specifically, not in general. Him specifically, we had met a few times regarding performance, and then if he had any HR questions, he would come up and see me.
Okay. And to the best, do you recall how many times he came to see you? Besides that Friday?
I don't know offhand because he might have come in for a question. I think he came in to talk about pay a few times. So I mean, under 10.
Okay. So it's not every day that you had contact with him? Not even every week?
Probably not.
And you testified that it's because when you talked about the incident, what came into mind was the person who was dismissed, the last person who was dismissed.
Well,
no, you talk about dismissed,
yeah.
Someone who had been dismissed.
Yeah.
Okay.
Termination, dismissal.
Okay, termination,
yeah.
Dismissal. Okay. As HR person, how many people have you dismissed in February before the incident, if you recall?
I don't recall the exact number, likely under 10.
Okay. So it's part of your job, you can say that dismissal was quite frequent there.
Part of my job, yeah.
You were part of, can we say that you were part of his dismissal?
Yes,
Was your computer broken?
no. However, my office is in a separate area from the shop floor.
Okay. Do you remember whose computer was destroyed?
Yeah.
What's the name of the person?
Eric Zagata.
Okay. And do you know how many people are supervised by Eric?
Like how many employees are directly report to Eric?
Yes.
At that time, probably about 20.
Okay. And how many people do you, if you recall, did you terminated who was
Under him.
under him?
That's hard to remember, but probably under 5.
Okay. And those 5 people included Mr. Brandon?
Yeah.
Okay. And the other 4 people, how long were they terminated? Before the incident?
Yeah, that's again hard to remember, but if I'm remembering correctly, Mr. Brandon's was, I mean, at least a few weeks in between any other welder termination in that area.
Did you during when you were told about the incident, did you see any forced entry?
No, not personally.
I have no further questions, Your Honor.
Redirect Ms. Fortunigo.
Yes, Your Honor. You were asked on cross-examination how often you interacted with Mr. Brandon. But can you tell me how often you saw him around?
Yeah. Anytime I would be on the floor, right, which isn't super often. I try to get out there at least once a day, and that doesn't mean I see every employee once a day. But break times, lunches, things like that, if I walk in the break room to get my water, coffee. I like to say I know all of my employees because I have about 200. So I speak with, the hourly staff quite frequently. So I was definitely aware of Mr. Brandon, talked with them numerous times.
Okay. Would you say you probably saw him once a week?
That's fair.
And you see him in the courtroom here today?
Mm-hmm.
Can you point him out by describing an article of clothing he's wearing?
Orange jumpsuit.
Okay. And Your Honor, at this time, I would like the record to reflect that the witness has identified the defendant as Mr. Brandon.
Okay, so the witness has identified the defendant sitting in this courtroom as DeQuarian Brandon, who's sitting next to. That's the extent of the identification. Any objection to that identification, Ms. Swansea?
No, Your Honor.
All right. Without objection, the witness has identified the defendant as DeQuarian Brandon, the person sitting next to Ms. Swansea.
Thank you, Your Honor. And one last question for you. Based on what you saw on the video and your experience, who is it that you believe is in that video?
I believe it was Mr. Brandon.
Okay.
Your Honor, that would be speculation.
And you can cross-examine. The indication is of why she thinks it's Mr. Brandon. I think we've covered that, but I'll allow you some time to ask questions if you choose.
I have no further questions.
Ms. Wanji, you can cross-examine on
Thank
the
you,
the last statement.
Ms. Prada, you did not see the face of the person on the
No.
video. You could not identify that person as Mr. Brandon.
No, not based on the video. No.
Okay. And you said that the person had braided longer hair.
Is that a yes, ma'am?
Yes.
I have no further questions, Your Honor.
All right. May this witness be excused from the people,
Yes, Your Honor.
from the defense?
Yes, Your Honor.
All right, you're excused, ma'am. Thank you for your
Thank you.
appearance.
You were good to go.
All right, any further proofs today, Ms. Fortunigo?
No, Your Honor.
Do the people rest?
Yes, they do.
All right. Any evidence today, Ms. Wanji?
I know, Your Honor.
All right. Motion for bind over, Ms. Fortunigo.
Yes, Your Honor. It's no secret to anybody in this courtroom that the big question here is identification. I am making the argument that we proved identification to a probable cause standard today based on the gait of the individual in the video. We heard testimony from Miss Spada that she had indicated that she was very familiar with Mr. Brandon. Maybe they didn't interact on a day-to-day basis, but she had seen him around. She would be very familiar with his gait. Additionally, we had testimony from both Mr. Darling and Miss Spada that the individual in the video had longer braided hair, which matched with what Mr. Brandon's hair had looked like nearly 2 days ago when he was terminated from the plant. That being said, there's other evidence as well to go towards ID. That Mr. Brandon was terminated from the plant only 2 days prior to the incident, that the damages were specific to Mr. Brandon's supervisor and the welding area. We heard testimony from Miss Spada that that there were no other welders terminated in that period of time, that Mr. Brandon would have been the only welder terminated. I believe she said a few weeks between any other welder. She did indicate other employees had been terminated. That's true. We also have the same truck involved in the theft. That was a truck that Mr. Brandon drove regularly on the job. We heard that from Mr. Darling. Additionally, knowing how to access and where to access all of the tools, the tool crib, how to gain access to the keys of that truck that Mr. Brandon was seen driving multiple times on the job. That being said, the people are moving for bind over on all counts here, breaking and entering, as well as malicious destruction of personal property, 1,000 or more, but less than 20,000. We did hear testimony today that the damages were well over $1,000. And the people would, if the court does find proper identification and move for bind over, the people would also ask that there be an added count 3, which is larceny in a building. With that, I do believe the people have met the elements of all 3 of those crimes to a probable cause standard, as well as location, venue. We heard testimony that this occurred at 1600 North Larch Street in Lansing, Michigan, County of Ingham, giving this court proper venue, that it occurred on or about February 10th of 2025. We did hear testimony that Monday is when the video was reviewed, when the damages were had, and that previous Friday would have been when Mr. Brandon was terminated. That Sunday being when the damages took place, which would have been the 9th. And then, of course, you've heard my argument on identification. So at this time, the people move for bind over.
Right. Thank you. Response, Ms. Monji.
Thank you, Your Honor. You know, the big element here is identification. The Ms. Espada testified that there were other people that were dismissed who work under the same supervisor that Mr. Brandon had. I'll say that Mr. Brandon, that she believed that it was Mr. Brandon because of his gait. Everybody can be say without any specification. I think that is very, very light. I don't know how many people, we don't even know, there was no indication that the person on the video was either black, white. There was no indication about the race of the person in the video. There was indication that that the person who was on the video was wearing had braided hair. But I can also say that a lot of people have braided hair. If you go outside there, you're going to find a lot of people with braided hair or dread. There was no specification of how tall the person was, how big the person was, the weight or anything else, nothing else that could be identified, that would say that it was Mr. Brandon. The only thing that they speculated on was that they thought there was someone who was dismissed on Friday. And for them, because the person was dismissed on Friday, that person came on and did all those damages. And also, Your Honor, there was no indication on how that person entered the place. There is not the element of breaking and entering here. The person to be inside the place had to have access. There was testimony here that Mr. Brandon, when he was terminated, had his badge deactivated. In order to enter that place, he had to have been escorted inside the place. Even the area where he's supposed to have been, to be able to go there, he had to be escorted in that place because he was terminated. And when we talk about someone who came to do damages, there was no testimony about the fact that when Mr. Brandon was terminated, that he was mad, that he said that he's going to be, that he said that he's going to come and cause damages to the place. There was no testimony regarding his interaction with his supervisor, whether or not there was any threats whether or not he threatened the supervisor. And also, Ms. Pada, who was part of the termination, did not have her equipment damaged. So say that Mr. Brandon was a person in that room is just pure speculation. Even on the basis of the probable cause is not met here. So we will ask the court to dismiss the case, find that there was no probable cause to say that Mr. Brandon broke and entered that place, or that Mr. Brandon damaged that place, or that even if he was a person who stole things in that place.
Thank you. Response, Ms. Fortunigo.
Your Honor, the people stand on their previous argument.
All right, so there's obviously an identification issue in this matter, but we're looking at, so at a probable cause level, probable cause being the second lowest standard in criminal law, reasonable suspicion being a lower standard, the date of February 9th, and I think that's the date requesting for bind over is February 9th. That was reported to LPD the following date, February 10th, but February 9th is met. So February 9th, 2025, the date is met at a probable cause standard. The location of 1600 North Larch Street in the city of Lansing is met at a location and venue at a probable cause standard. The offense of breaking and entering a building with intent, which is count 1, and malicious destruction of personal property, 1,000 or more, but less than 20,000, 5 year is also, is met at a probable cause level. There is some indication that the defendant didn't have access, but there's videos showing a person as having access, and then the speculation there's only so many ways to get in the room, and one of the ways is to climb over. But that wasn't seen. What was seen was the person was in an area that they're not supposed to be in, and so count one, count two are count one and count two are met at a probable cause level. The people have asked for count three under 750.360 for larceny of building, which I believe is a 4-year felony. Is that correct? An added count three?
I believe it's 10-year, Your Honor. I just have the jury instruction up. Let me pull up.
All
the
right,
warrant
I
manual.
just have it called a felony under 750.360.
It
but-
would specifically be larceny 1,000 or more, but less than 20,000. That's a 5-year.
Okay, so that's not larceny of building.
Oh, correct. I clicked on the wrong one. My apologies.
Yeah, that's a money amount
Yes,
on
yes,
larceny.
absolutely. Here we go. Clicked on the right one. 4-year.
4-year 750.360.
Yes.
Okay. All right, so that's the added count three. So we come down to identification, and identification is there's a motive because Mr. Brandon was recently let go, and then there's the video concerning of what happened in the weekend. The indication is that there is a face, a mask or gaiter. He called it a gaiter. I know what a gaiter is. That's to be used to go over. It's used in welding, but it's also used in hunting and fishing to protect any type of viewing of the individual, so to speak. So there was problems with the identification of the individual on the video. So identification is made through, and as indicated, is made through motive, and then it's made through some things that are consistent at a probable cause level, and that would be the hair and the gait of the person who they had some access to, who was recently let go, and then he appears in the video, and that's how they make identification. That at a probable cause level, I find that to be met at a probable cause level, and so I will bind over on and I had the opportunity to witness. One was Greg Darling. Witness two was Becca Spada, and I can't say the hyphenated name just because it's hard to say and it's not spelled. But there is a hyphenated name. Those were the two witnesses concerning this. So I'll bind over on count one as met at a probable cause level at location of venue, ID, and date. But identification is an inference. It was not made. It was made through what he was wearing, what Brandon was wearing, the motive involved, and then something of a hair of distinguishable hair, because they could not, because nobody said on the record that Mr. Brandon is the same person in the video. That just wasn't said. But inferences can be made at a probable cause level, and probable cause is our standard. So count one, count two, and an added count three for larceny of building under at 750.360 are bound over plus LIB 750.360. And so I'll indicate that the examination was held on today's date, which is April 16th, 2026. And it's bound over on the charges in the complaint, and then plus LIB 750.360. Anything else to come to the court's attention before I sign the bind over documentation, Ms. Fortuna Gill?
No, Your Honor, thank you.
Ms. Wanchi?
Nothing, Your Honor. Thank you.
All right. We'll leave bond as remains at the same, and I will sign the bind over documentation for today's date. So your time in district court is done, Mr. Brandon. You'll get your next date to appear in circuit court from your attorney, Ms. Wanji. All right, sir? All right, anything else for the record in docket 2503-183, Ms. Fortuna Gill?
Not for the people.
Ms. Wanji? Anything else, Ms. Wanji?
My client would like me to address bonds.
All right, I've closed, we've closed and I've signed it, but you can address bond.
Thank you. Obviously, one of the elements of that you have to take into consideration is the flight risk. I don't believe that there is any indication that my client failed to come to court when request to do so. He has support in the family, in the community. And he also, he worked here and was a resident of Ingham County. As for this is a non-violent crime. So we do believe that the McLean would like to have to address a PR bond at this time. I believe that his bond is 300 casualty. And it's already, I guess if the magistrate set up that kind of bond, it's because the elements she thought, or he thought that there was, or the judge thought that there was no flight this year. So we will ask the court to transform the bond to a PR bond. Thank you.
In response, Ms. Fortuna Gill, I would assume that the magistrate set the bond because and I don't know, I can't speak for, but it appears that the defendant was in the Calhoun County Jail at the time.
Yes, Your Honor, that's my understanding as well. The people would leave it to the court's discretion.
Okay, I'm gonna leave bond it is at $300 cash surety, which is a low bond concerning that this is a 10-year felony and a 5-year felony and now and a 4-year felony. So we'll leave bond. So the motion to reduce bond or modify bond is denied. And you'll get your next date in circuit court from your attorney, Ms. Wanji. Thank you for your appearance today.
Judge,
Who do you want to bring up? That's a dismissal, or you could waive his appearance, or do you want him brought up?
You're saying if you're gonna bring anybody out, yeah. So that's Mr. Brandon.
So you would do a waiver, Houston?
Yeah.
Is he here or does he need to be brought up?
No, he's here.
Okay, so who needs to be brought up? Because I don't have that list. Garcia, we're gonna run that one. I know, it's noon, but yeah. What about Michael Pearson? That one can be brought up.
Okay, so Michael Pearson.
You can bring up Michael Pearson.
Okay, right.
Or wait, we can waive his appearance as well. That's also going to be a dismissal.
Okay.
Okay.
So
Just Garcia.
I don't know what time.
Pearson, okay. Ms. Wanji would like Mr. Pearson brought up.
All right.
Sorry, there's gonna be another one.
I know.
Okay.
So bring up, yeah, for Michael Pearson, so
We
place
had
that on the
so
record.
many like very chill preliminary exam days that it was coming for us.
Oh, I know.
That's fine.
Absolutely, let's get
I saw-
everything else out of the way.
I saw
Sure.
Mr. Goodrich here,
Yes, he's here on BAW,
but he's left.
which I believe is a failure to appear.
All right.
That is a bummer. Okay, we can go on.
Do you want to go on
We can go on
Borquin?
Borquin and we would be waiving his appearance.
And then he's
Oh,
in
yeah.
lockup, I believe, but Ms. Wanji, you're gonna go down and see him. You'll let him know what we do here.
Okay.
All right. All right, so we're on the record in 26, so we'll waive his appearance. We're on the record in 26-00651. That is People of the State of Michigan versus Mark Borquin. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Wanji.
Melanie Piwanji for Mr. Pearson.
All right, this is the time set
Borquin.
for Mark Borquin. This is the time set for preliminary examination. Ms. Fortuna Gill, how are we proceeding?
Your Honor, the people cannot proceed on this case today. We still do not have the complaining witness present. I cannot in good faith ask the court for another adjournment without knowing exactly when we would be able to have him present. That being said, I do believe that it is my office's intention to reissue this case if and when we are able to gain contact with that witness. I do anticipate a motion from Ms. Wanji.
Your
All
Honor,
right, Miss Wanchi.
thank you, Your Honor. We are ready for the probable cause conference, so we will ask for dismissal since the people are not able to meet the probable cause.
All right, based on the defense motion, the people are unable to proceed. The complaining victim has failed to appear and contact, although there's been some contact, is it unsuccessful contact? It would appear that because he failed to appear.
Yes, Your Honor. It's my understanding that the victim is in treatment.
Okay. All right, so I will dismiss without prejudice based on the defendant's motion to dismiss. And we can have that printed out. And so that'll mean Mr. Borkman should understand that's dismissed without prejudice. So the people may reissue if they choose to. And it sounds like they may after they speak to the complaining victim, once the complaining victim is released from the treatment center. But for our purpose today, the case is dismissed. And I'm going to add to your resume and see if somebody can grab it off the printer, so we can add that to your job descriptions. All right. So I'm in possession of the order of acquittal based on defendant's motion to dismiss without prejudice. We're waiving Mr. Borkman's appearance. We understand he's in lockup, and Ms. Wanji will tell him that the case has been dismissed, but may be reissued because this is being dismissed without prejudice after discussion with the complaining victim. And then you may want to give him a copy of the order, Ms. Wanji, because there was a GPS associated with this, but I don't think he's been out. And there's a no contact order with the complaining victim. So it'll be in the computer system for, I would think 3 to 4 hours. So if he's going to be released, he should understand that he may be subject to some of the pretrial conditions until it's purged from the computer system. Anything else for the record in 26-00651, Ms. Fortuna Gill?
Not for the people.
Ms. Wanchi.
Not for the defense.
All right, so that's Mr. Borkman's file. Now Mr. Goodrich is here. I called Mr. Goodrich Dale Goodrich earlier. It's Luke Goodrich.
Yeah, so we would be ready on Mr. Baugh. We're also ready on Mr. Houston.
All right, let's go on Mr. Baugh.
Yes.
And then we'll go on.
Oh, so then we're not ready.
Well, we're ready,
Okay. Oh, Your Honor,
You need
it's
some
come
time
to
to
my
discuss that.
attention that we would be running that exam as well.
Okay.
So we are not ready on that matter. There's some other stuff we can get out of the way.
All right, which cases are we? Which case are we calling? We're bringing up Mr. Pearson.
Yes, we can go on Houston.
Houston, Jerome Houston. All right, so we're on the record in 25-03602. That's people of the state of Michigan versus Jerome Houston. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Wanchi.
Good morning, Your Honor. No, good afternoon. Melanie Wanchi for Mr. Houston, who's
And-
at the council table.
And sir, you are Jerome Lamar Houston, is that correct?
Yes, Your Honor.
Right, thank you. This is the time set for preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. It's my understanding the defendant wishes to waive their right to a preliminary examination. Oh, yes, you're right. I apologize. I have the wrong note on here. It's been a long morning. It's my understanding the defendant wishes to hire a private defense attorney. So we would, the people wouldn't object to an adjournment for the defendant to do so.
All right, and for our purposes, Ms. Wanji, Mr. Houston is going to seek counsel, private counsel.
Yes, Your Honor.
It would, for our flexibility in scheduling, and so we don't know private counsels, is Mr. Houston prepared to waive his right to a prelim within 21 days, just for some flexibility in scheduling?
Yes, Your Honor.
All right. So, Mr. Houston, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Melanie Wanji, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding, it is your wish to seek your own counsel, okay? And to waive the, so you wouldn't be waiving your right to a prelim in general, just within the 21-day period, so that you can seek counsel, and it gives us some flexibility for scheduling purposes, especially since we don't know the schedule of the person that you're getting to represent you. Is it your wish today to waive your right to a prelim within 21 days? And so the defendant has waived the right, and you are represented by counsel, Ms. Wanji. So, I mean, so we'll waive your right to a prelim within 21 days, and then we'll adjourn the preliminary examination. And then I would think with new counsel, we're going to set it for PCC first.
That would be my request.
Yeah. So we'll set for PCC and prelim, but we'll probably set it we can go past probably into May.
So May 15th would be a month, 4 weeks, would that be?
That should be sufficient to get the discovery, the appearance, and everything on board. All right, so we'll set it for May 15th for PCC.
PCC at 8:30.
PCC at 8:30. And then for preliminary examination.
That's a week later.
Yeah, usually a Thursday or Friday. So it'd be the corresponding or Friday, the 22nd.
Yep.
Okay.
At 8:30.
Okay, so set for May 22nd at 8:30. So your new counsel should know the PCC is set for May 15th and the prelim is set for May 22nd. They can contact the court or Ms. Wanji. She'll have those dates. And then once they file an appearance, discovery will go to them instead of Ms. Wanji, all right? Anything else for the record in 25-03-602, Ms. Fortuna Gill?
Not for the people.
Ms. Wanji?
Not for the defense.
All right, Mr. Houston, we'll see you on May 15th for PCC. That could be attended via Zoom. And the prelim will be live in person on the 6th floor, just like we are here today, okay? All right, you're all set, sir. Thank you for your appearance. Thank you.
We can go on, Mr. Bog. The people are going to be amending this to a misdemeanor.
All right. So that would be. So let's go on BA first, and then we'll go on.
Then we can go on Pearson, because that's.
Did you want to go on Pearson first?
It does not matter to me.
Let's make room for, and then we'll go on. So we'll do Pearson first, and then do we want Garcia brought up after
Yes.
we're done with Pearson?
Yes.
All right, and then we'll do in the interim. We'll do the BA case. All right, so we're on the record in 26-00854. That is people of the state of Michigan versus Michael Pearson Jr. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
And Ms. Wanji.
Good afternoon. Good afternoon, Your Honor. Melanie Wanji for Mr. Pearson, who is at the council table.
And sir, you are Michael, I have you Michael Anthony Pearson. Junior, thank you. This is the time set for a preliminary examination in the matter. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor, the people are unable to proceed on this matter today. We do have the complaining witness present. However, they are unable to proceed on this matter. And we are unable to proceed without her testimony. I do anticipate a motion from Ms. Wanji.
All right, Ms. Wanji, motion from you after the response to Ms. Fortuna Gill.
Your Honor, we do believe that there is ground for a request for dismissal without prejudice.
All right. So I'll have printed out a at the defense request a dismissal without prejudice. It appears based on the representations of the prosecutor that the complaining witness was present or is present, but is not on, but they cannot make the proofs. And so the people are unable to proceed today. That is probably so that is for my signature.
Yes.
So I'm in possession of the nollie pros based on defendant's motion to dismiss without prejudice, which means the people could reissue Mr. Pearson if they choose to, but realistically, for our purposes today, the case is dismissed. All right, sir? And there's no the GPS, but the defendant has not made bond, so there's no, do you have a GPS on? Okay. And then there's a no contact order, so you should keep a copy of this for your records, because it probably takes about 4 hours to purge from the court system, all right? All right, anything else for the record? I've signed the order of acquittal or dismissal. Anything else for the record in 26-00854, Ms. Fortuna Gill?
Not for the people.
Ms. Wanji?
Not for the defense.
All right, Mr. Pearson, you're all set. Good luck to you. Okay, sir?
Thank you.
Tax stats of failure to appeal. Oh, okay.
Please advocate what I haven't been able to
Got it.
call them.
Let's go ahead and put,
We can go on
Take-
BA or Hackstead.
well, we're gonna go on bond next,
Perfect.
but let's put Taylor on the record. That's fine, because I signed that stipend order yesterday.
Yes.
So we're on the record 26-00652. Appearances for the record, that's People versus Montreal Taylor, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
It's my understanding that this was adjourned from today's date, so I'll take it off. I signed a stipend order between Ms. Fortuna Gill and Ms. Schroeder. Ms. Schroeder had a conflict. I think she's in trial, and or thereabouts. And so we've adjourned the matter at the request of the parties. Anything else for the record in docket 26-00652, Ms. Fortuna Gill?
That is correct, Your Honor. It's my understanding that Ms. Schroeder's, that the jury did come to a conclusion at the very end of business yesterday. So of course, Ms. Schroeder would have had no idea. She would have been able to be here today,
Right.
this morning. The people have no objection to that, of course.
All right, and then let's go on Mr. So that's all for the record in 26-00652, and then we'll go on Mr. Ba.
Yes.
Afternoon, Your Honor.
Good afternoon. So we're on the record in docket 25-03515. That's People of the State of Michigan versus Jonathan Ba. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Goodrich.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Baugh, who is standing to my right.
And sir, you are Jonathan Ronald Ba, is that correct?
That's correct.
All right. This is the time set for a preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. The people wish to amend this felony count to a misdemeanor use. So therefore, there would be no need for a preliminary examination, and this would go on the misdemeanor docket.
All right, so you want to, we want to amend count 1 to use of methamphetamine.
That is correct. I can get the pack code for you.
Yeah. I don't think I have it. Let's see. Nope, I don't have it. Oh, there's a page 2. Still don't have it.
Okay.
Oh, nope, I do have it.
Okay, I have it as well.
I have 333.7404. 2A-A.
That is correct, Your Honor.
And that's punishable by 1 year and or $1,000. And then your indication was you just want it set for pretrial?
Yes, please, Your Honor.
All right. So we'll set it for pretrial on the count 1 of use of methamphetamine. And it'll be set for pretrial. I don't know the date of the pretrial. We might be able to give you the date of the pretrial, or
How many weeks or?
I would think at least 14 days. So it'd be 2 weeks.
That's not gonna work.
Yeah, I mean, but I would think for pretrial purposes, it doesn't really matter. I don't think final pretrial, we probably,
That's correct. We don't need to send out subpoenas for pretrial. Also, all of my, that would pretty much be irrelevant in this case anyway, considering all the witnesses are police officers.
all right. So, I mean, so we can set it as soon as next week, I would think. So it would be, or we can set it after. We'd probably set it May 4th would be, so it'd be so we're looking at the 20th, is it the 27th open? I think I'm gone that day. So the 20th or the 4th, it's kind of your pick. Or whatever, Mr.
I know I have something May 4th, but it may not be a problem.
All right. I mean, we can work around, but
Go to James or
It
Tyler?
might.
Okay.
it might.
It might. I'll probably.
Because we know somebody from your office will be here,
Yes.
but it may not be.
Yes, that's true. So yeah, if it's fine with Miss Fortuna Gill, we'll certainly.
Either
make it
date's fine with me. I can do the 20th.
All
Is
right.
that the one that you have a conflict with, or I thought you
The
said the 4th?
4th.
Okay, perfect. We can do the 20th.
All right. Let's do the 20th, which is April 20th. How's that look?
So that's-
Okay.
Yes.
So we'll set it for April 20th at 9:30. And then Mr. Bott, there'll be somebody here from the Public Defender's Office. If it's not Mr. Harris or Mr. Ned, Mr. Harris or Mr. Smith, it could be Mr. Goodrich, all right?
Is that
All right.
setting a pretrial?
Yeah, just set it for pretrial on April 20th at 9:30. Anything else for the record in 2503-515 with the amended complaint? So it's now a use, Ms. Fortuna Gill.
No, Your Honor, thank you.
Mr. Goodrich.
No, Your Honor, thank you.
You should be all set, Mr. Baugh. We've set for April 29th, April 20th at 9:30. Thank you.
He could do Zoom on that or no?
I want to talk to you.
Okay. Yeah, let's do it in person. Just, yeah, just to have everybody here.
I'll print that in a second.
Okay, I will. Grab it from the printer.
We, Hackstad, that defendant is not here, and there's explanation.
All
We
right.
need to go on the record on that. I think we are ready.
X. And
Is there one for me and Mr. Klein or one for you?
What else you got?
You signed it, you just signed it, the,
To the bar.
no, the on Google.
I think one is just for him and then one goes in.
Okay.
We did Borkin. It was dismissed on your motion, but we did that all on the record.
I did not know, I don't know if we just signed.
The judge signed the nolly, yeah.
on
Borkin,
Orkin, yes. Yeah, I signed the nolly.
so what are we?
So we're bringing up Garcia and we're on Hackstead.
Yes.
All right.
Okay.
All right, so we're on the record in 26-00801. That is People of the State of Michigan versus David Hackstead. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Wanji.
Good afternoon, Your Honor. Melanie Elpiwanchi for Mr. Hackstad.
All right, this is the time set for preliminary examination. It was set for 8:30. It is now 12:17. And Ms. Wanji, have you had some contact with Mr. Hackstead, or at least for his fail to appear?
Well, he called our office. It's my understanding that he's at the Cape Pet in Kalamazoo, but I think it's Kalamazoo. He's in the treatment facility. And he called twice the office, and the first time he left them a phone number. We tried to call that number, and it's the number of the KPEP, but nobody's answering. But I know that he is in treatment, Your Honor.
So you've had some contact with Mr. Hackstead, and you're trying to confirm whether he's at the facility.
Yes.
All right. So that would explain his non-appearance because if he's in treatment. Ms. Fortuna Gill, how did you want to proceed?
Your Honor, I would be okay with a courtesy reset on this. I do believe that the last time for the PCC, Mr. Hackstead was in treatment. We knew that then.
And considering that he's been contacting the public defender's office, I have no problem with the courtesy reset on this.
All right, we can do a courtesy reset for good cause. Because it does appear that Mr. Hackstadt is in treatment. And then we'd probably set it for a PCC first, don't you think?
Yes, yeah.
Yeah. So do we want to set that out like in the beginning of May? I don't know how long he's going to be in treatment.
That would be fine.
Yeah. So we'll set the PCC for May. Let's see.
That's 3 weeks. You want
Yeah, let's
4
do
weeks?
let's do the PCC for May 7th, but he might still be in treatment. And you can let Miss Fortuna Gill know if he's still. You should have more information concerning the treatment center, and then we'll set it. If we find out, then we'll set it for May, the prelim, the week after.
Sure.
So May 7th is the PCC.
What time, Your Honor?
Hang on.
At
I gotta get this one set for one here.
Sure.
But what time is the PCC? 8:30. All right. The 14th.
After, like, unrelated. Yeah. I'm hoping.
Okay, May 14th.
That we can get through it. If she doesn't, I'm gonna do something that. That's gonna create some.
All right. So we'll reset the PCC for May 7th at 8:30, and then we'll reset the preliminary examination for May 14th at 9. Concerning Mr. Hackstadt. And then we'll have more information at the PCC, the May 7th date, what his out date looks like from the rehabilitation center. All right, anything else for the record in 26-00801, Ms. Fortuna Gill?
No, Your Honor, thank you.
All right, Ms. Wanji.
No, Your Honor.
All right. Then did you need a minute on is this Mr. Garcia?
Yes.
Your Honor, I do need a brief.
To get your witnesses.
To be completely transparent, it's because I'm 28 weeks pregnant and need to go to the restroom.
Okay.
And then I'll be back.
Then you can contact your witnesses. If this,
Yes.
So I've got Mr. Garcia is going to have a prelim. But I think that's our last case for this morning. Is that?
Yes, it is. I have yet to hear from Ms. Patrick as to whether we will be.
On the 2 130s?
Yes, whether we'll be running more today.
All right, just come get me when you're ready, all right?
Will do, thank you, Your Honor.
Sorry. Sign the.
Yeah, it's gonna be right here, I think.
Huh?
It's gonna be in here.
Oh, okay. We got a leak in there. Some water leaking from the ceiling up there.
In our hallway?
Yep. Something's still like.
Oh, I can make it.
Thank you. I got that sanitizer. I don't know what that.
Oh,
Last time we had a leak, it was coming from the bathroom up there.
And then I gotta run to the bathroom too.
Okay. Oh, man, you go ahead. You got to stand up. Yeah.
Do you need one for yourself or you need?
Yes, I need
For
one.
two?
myself.
Okay.
What's that? What we gonna do?
And that's a-
Building just falling apart.
Need to move sooner.
Yes. Okay.
I'll just set.
Oh,
Heck, here. I'm gonna, I'll be right back.
all right.
very long morning. Okay, so just so you know, I only have the one witness. I'm gonna take her testimony. It should be enough. If somehow it's not, I'm gonna have to ask for a continuance if I don't have an officer. I think it should be fine.
You sure?
No, I'm not sure. I'm never sure of anything.
If not, let's ask for continuance.
I don't want to do that because she's been here all day and she's ready to go. But I know, and I think it should be enough. But I just want to be transparent with you. But I'm gonna take your testimony today. Okay. Don't be mad at me.
No, I'm not. Judge Jim will be mad at me because he changed my schedule this morning for this afternoon.
Oh,
Because of
no.
that. And all of those are final critical. I'm trying to send it in.
Okay. We are ready whenever you are. We're ready whenever you are.
All right, I'm deglittering.
Yeah, I got glitter on me.
Yeah, we've heard. So how much? This is
Yeah.
crazy. We don't even know what it's from.
Somebody like cursed. Judge.
I don't know. It's
But
like
yeah.
everywhere. Well, is any just that one chair though?
But no rush, just whenever.
All right.
Yes, whenever. Picked a crazy day to be subbing in, David.
Honestly, this whole week has been, we made almost another viral video yesterday.
Oh, yeah.
Again. On,
On a landlord tenant day? Is that what it is?
and he was, I don't know if he's exactly a sovereign citizen when he was talking.
Oh.
language of it. And, you can't live in somebody's house free and then say, I'm not a citizen of the United States.
Right.
No. Yeah, it made it to, it's on YouTube. And the crazy part, just kicked him out, and he came back later trying to file a motion. And the time you're gonna file a motion to spend that money, you
Right.
pay your rent, literally. And of course, we had the altercation Monday. Was it Monday when the little hiccup over here?
Oh, yeah.
Oh, my
Yes.
God.
That was supposed to be my witness. That's how it goes.
That was, yeah.
That case is crazy. And my office reissued it. So
Oh, they coming back.
it's coming for you.
Oh.
I could get assigned to Judge Simmons.
Oh, God.
Oh, my goodness.
I'll tell you what, she tried over there, they promise you she's gonna be held in contempt. Oh,
Yeah,
promise
for
you.
sure.
Not going down like that. But the guy, he fueled it. I mean, he kept
Yeah.
edging her on, and then when
That's-
she get loud, he gets quiet. Let her take the fall for it.
Yeah, he hates me. He's the victim on that case.
All rise.
Right, you can be seated. And this is docket 26000519. As people of the state of Michigan versus Jacob Garcia. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Swanji.
Good afternoon, Your Honor. Melanie Luanchi for Mr. Sorry, Mr. Garcia, will secure the council people.
All right, sir, you are Jacob James Garcia, is that correct?
Yes, sir.
All right, thank you. This is time set for preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Your Honor, the people would like to run the preliminary examination. We are prepared to do so.
All right, so we're gonna run my understanding is we're running the prelim. There's nobody in the courtroom right now, but if you see anybody come in, I'll invoke the sequestration order. So we'll have one witness not watching another witness testify. But obviously, you know the case better than I do, so I'll wait to hear from counsel. Anything else to come to the court's attention before we start the preliminary examination, Ms. Fortuna Gill?
Briefly, Your Honor, I just want to be fully transparent. I do anticipate one witness only. That being said, I cannot predict exactly what testimony is going to come in today. It may very well be possible that at the end of testimony today, I have to ask for a continuance to get a police officer here to supplement the testimony. That, of course, is not my plan.
Right.
But it's always a possibility.
All right. With that understanding, anything else to come to the court's attention concerning this matter, Ms. Fortuna Gill?
No.
Ms. Wanji, anything come to the court's attention concerning sequestration or anything else?
No, nothing.
All right. With that understanding, we will start the preliminary examination concerning Jacob Garcia, and the people may call their first witness.
Thank you, Your Honor. The people called Rosemary Arnold. So I do believe her last name has changed.
All right, Ms. Arnold, I'll have you come up here.
Different, right?
Okay, you can stand right in front of me. All right, so I'm gonna have you spell your first name and last name for the record, ma'am.
Rosemary, Arnold, Arnold.
So how do you say your first name?
Rosemary.
Rosemary, okay. Thank you. Please raise your right hand. Do you solemnly, so you
Your
have
Honor,
to,
she cannot raise her right hand.
okay.
She's unable to do so.
All right, so I'm gonna raise my right hand, and then you can indicate, do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Okay, you can have a seat here, Ms. Arnold. Let me know if you need anything. The microphone goes right to the court recorders there, so it doesn't project or amplify.
Okay.
But you sound like you're able to project.
Okay.
So when you're ready, Ms. Fortuna Gill.
Yes, thank you, Your Honor. Miss Arnold, do you know why you're here today?
Yes, I do.
Okay, do you recall anything noteworthy occurring on November 25th of 2024?
Yes, I do.
Okay, can you tell me a little bit about how that incident began?
It began at like really early in the morning, like 4 or 5 o'clock. Mr. Garcia asked to get something out of my car. So I gave him my keys to do so.
Okay, and Mr. Garcia, how were you two affiliated?
We were dating.
Okay. So on November 25th of 2024, you were in a dating relationship with Mr. Garcia?
Yes.
And is that Jacob Garcia?
Yes.
Okay. And do you see him present in the courtroom today?
Yes, I do.
Can you describe an article of clothing he's wearing for me?
A white jumpsuit.
Okay, Your Honor, at this time, I would like the record to reflect that the witness, Ms. Arnold, has identified the defendant as Jacob Garcia.
Any objection to the witness identifying the defendant as Jacob Garcia?
No, Your Honor, thank you.
Without objection, the witness has identified the defendant. You may proceed.
Thank you, Your Honor. And can you tell me where you and Mr. Garcia were this day when you said you handed him the keys to your vehicle?
He obviously was up standing around. Then he sat at the end of a twin size bed that we have. I was sitting in the bed already. I had my back up against the wall.
Okay. And
at the head of the bed. I'm sorry.
That's okay. I understand. Is the head of the bed against the wall?
Yes. It was
Okay.
like a twin bed. It was up against the wall over here, and then it was in front of the bed over here.
Okay.
So I was sitting at the head of the bed.
Okay, and you're motioning to your right?
Yes.
Okay.
Right.
Can you tell me what happened after you gave Mr. Garcia the keys?
He wanted to leave and I didn't want to.
Okay, he wanted to leave together, both of you?
It's hard for me to say. I don't remember.
That's okay.
Where's your room located? Where's the bedroom located?
The second story.
Okay. And where's the house, the second story located? The address?
818 Riley.
Okay. You may
And-
proceed, Ms. Fortunato.
Thank you, Your Honor. And 818 Riley Street, is that in the city of Lansing?
Yes.
Is that in the county of Ingham?
Yes, it is.
State of Michigan?
Yes. It's by Fleetwood Diner.
Okay. And is that where the entirety of this incident unfolds?
Yes.
Okay. So tell me what happens. So you and Mr. Garcia are disagreeing.
Yes.
On whether or not to leave. Tell me what happens next.
He likes to say stuff under his breath when he gets mad, and I didn't want to deal with it, so I was in the process of moving out, and I had only clothes that were at his house, so I made the decision at 4 or 5 o'clock in the morning to just leave, because how he was acting, because his parents lived at that address. and-
Okay. Sorry, I don't mean to cut you off. I just want to make sure I'm understanding everything. So the address you're at, that is Mr. Garcia's address?
Yes, it's his parents' address.
Okay, understood.
But
And
we were living there.
okay, understood. You were both living there
Yes.
together. Okay, got it. And Mr. Garcia was angry that you didn't want to leave with him. So you decided to leave the home altogether. Is
Yes,
that
I was begging him for my keys back.
okay?
And he was just telling me no, arguing with me.
So at this time, Mr. Garcia is still in possession of the keys?
Yes.
Okay, and about how long do you think has passed between when you gave him the keys versus when you were asking for them back?
Like the first time I asked him for the keys back,
Yes.
probably about 20 minutes, 30 minutes.
Okay. So you indicated you had asked him for the keys back more than once. Tell me about that.
He wouldn't give me the keys back. They were in his pocket. And I was like, please just give me the keys. I want to go. And
Okay.
he wasn't.
And how did he react to you asking for the keys back? And
A couple times he got up and started wailing on me, punching me, but I put my knees up to defend myself, to block the punches.
okay, so this happened in multiple incidents?
Yes.
Okay. And you said wailing on you, punching on you, do you know approximately how many times you were hit?
Like 5 or 6.
And when you say 5 or 6 times, is that in totality or is that each time he would
Just
get up?
that situation was 5 or 6 times.
Okay. So were you ever able to leave?
After he was hitting me a couple times, punching me, I asked for the keys back one more time and he threw them, like he was at the edge of the bed, right, like at the middle of the bed, and I was still at the head of the bed.
Okay.
And he chucked the keys at my face, close range, and it sliced it, and I instantly had a huge black eye, and I started pouring blood, and then he stopped fighting with me because it got serious.
Okay, so when you said sliced it, you motioned towards your eyelid. Can you
One of-
describe where? the
It was
cut
like right in here.
Right in here, and
Yeah.
you're motioning right on the top of your eyelid, but
Yeah.
below your eyebrow?
Yeah.
Okay. And do you recall if that it was the left side or the right side of your face?
My right eye.
Okay. And you indicated at this time, Mr. Garcia had stopped assaulting you?
Yes.
Okay, and what did you do?
I got the bleeding stop. He obviously wasn't gonna let me leave, so I just laid down and I fell asleep again
Okay.
till like 11.
Okay, and what happened after you woke up?
We didn't really talk much. We didn't really interact. But then he asked me to take him somewhere.
Okay, do you recall where he wanted to take you to take him?
I know, right off the top of my head.
That's okay. So you just recall that he wanted you to drive him somewhere?
Yeah.
Okay, and what was your reaction to that?
I didn't want to.
And did you tell him that?
Yes.
And how did he respond?
Not good. But like basically I told him I don't want to reward bad behavior.
Okay, and when you say he responded not good, what exactly does that entail?
Talking under his breath, threatening me, but I just learned to ignore it.
And when you say he was threatening you, do you remember at all what he was saying?
No, I don't. It's been a while.
Okay. It has been a while. Let's see. Do you know, did you ever end up taking Mr. Garcia anywhere?
No, I didn't.
Okay, so what happened?
It was like 3, 4 o'clock, I think, in the afternoon. And I wanted out of there. So I signed in to DoorDash or Uber Eats or one of the two, I can't remember.
Sure.
But then my phone went off and I got an order. I accepted it.
So when you say that you signed in to DoorDash or Uber Eats, some food delivery app,
Yeah.
do you mean as a worker?
Yes.
Okay, okay. So you signed in to work to
Yeah.
get an order. And then what happened?
Then I got an order while I was still at the house, but I didn't tell him about it right away. I didn't tell him till I was already at the bedroom door, walking out of it.
Okay, so as you were leaving, you told him, what exactly did you say?
That I was going to do deliveries.
Okay, and how did Mr. Garcia react to that?
He was very angry. He got a pole.
Okay, and when you say pole, can you describe that a little bit better for me? Do you know what it was made of?
I think it was like a tension rod that you have as like a shower curtain.
Okay, was it long?
Yes, it was long.
Okay, would you say, I'm thinking shower curtain, would you say longer than 3 feet?
It was one that you can retract. So it
Okay.
was like this big.
I understand. And when you say this big,
Yeah.
about 2 feet?
Yes.
Which, okay.
2 to 3 feet. You let the record reflect that the witnesses indicated 2 to 3 feet, based on some of the hand motions between herself and then the assistant prosecutor.
Thank you, Your Honor. And And the pole, I know some of these tension rods, is it plastic? Was it metal? Do you know?
It was metal, I think.
Okay, metal.
It definitely sounds like metal when you tinted off stuff.
Okay, and so tell me a bit about that. Tell me about why he got this pole. What did he do with it?
As I was like hurrying up and walking to the car, he was obviously right behind me. He opened up the passenger door, said some things I don't remember, but then he like whacked my rear view mirror with it and it broke the mirror.
Okay. In the rear view mirror inside of the vehicle?
Yes.
Okay, so Mr. Garcia opens the passenger door and hits the rear view mirror inside of the vehicle with the, thank you. And so just so I'm clear, he followed you from the second story bedroom?
Yeah.
All the way down to the vehicle?
Yes.
And did he have the metal pole in his hand the whole time?
Yes.
Okay. And was he saying anything or doing anything with the pole while he was following you?
I can't remember. He was saying something, but I can't remember what he was saying.
Okay. And after the rear view mirror broke, did anything else happen after that?
I got away from there as fast as I could and I drove to the Y Street police station and I called 911 and I asked for an officer.
Okay, so when you say you got as far away from there as possible, or I just want to make sure you were in the driver's seat?
When he opened the passenger door and broke the rearview mirror, I was in the driver's seat and I would have just took off, but my door was open and he was inside the car.
Understood. And how did that make you feel at that time?
That wasn't the first time he did that, but at that time it was exhausting. It was kind of scary. Like it was like walking on eggshells the entire time I was with him. Like if anything wasn't the way he wanted it, he would be cool.
Okay. And had you ever been hit with that pole before?
The pole, no.
Okay. Had you been hit with other objects?
Over the course of 4 years, yeah.
Okay. And did you, at the time, did you think that you were going to be hit with that pole?
Yes.
Okay. And what made you think that?
Just the way he was tapping me on the arm, this arm, because the passenger door was open.
Understood.
He kept tapping on the arm with the pole.
So he did touch you with the
Yeah,
pole?
but not like, he didn't hit me with the pole, he threatened me with it.
Like
Like,
touching you
yeah.
with it? Okay, I understand. And when he was touching you with the pole, did he say anything?
I don't remember.
Okay. And then you said you were able to get out of there. So explain to me how that happened. Did Mr. Garcia leave the vehicle? How did that work?
Eventually, he had the pole and he turned around and he walked like he was going back into the house. And Riley Street is a dead end where his house is, so I had to like turn around, but I didn't. I reversed out of there, and then I turned around once I got on Lions.
Got it. Understood. And you called the police. Did the police come?
I went to the Wise Road Police Station.
Oh, that's right. My apologies. You
Yeah.
did indicate that you had went to the police station. And did you give the police a statement then?
Yes, I did.
Okay. And was that the end of your contact with Mr. Garcia? That day, I should say?
Yes.
Okay. Can you, did Mr. Garcia try to contact you that day?
While I was at the police station, the officer, she observed him calling me like 45, 50 times.
Okay.
But I didn't answer.
Okay, and you say the officer observed it. Did you observe it? What, did you have your
Yes.
phone at the time?
Yeah.
Okay. And you didn't answer. Were there any messages left that you recall the content of?
I don't remember.
That's okay. That's perfectly okay. So you said 40 to 50 calls?
Yes,
Okay, and you didn't answer any of those?
no.
I have no further questions for this. That's not true. I do.
All right.
Sorry about that. Miss Arnold, can you tell me, at any point during this interaction, did you try to call 911?
I did. Right when he threw the keys at my face, I tried to call 911. It got disconnected and then they called back, but while they popped up on the caller ID, he took my phone and it tried smashing the screen.
Okay, and this happened when you were on the bed.
Yes,
So we're going back a little bit. Sorry about that. This was this before or after your eye got cut or right above your
he
eye?
cut my eye and then I tried to call the cops.
Okay, and you were able to, but it got disconnected?
Yes,
And then when 911 called back, Mr. Garcia took your phone at that time?
yes.
Okay, thank you. I have no further questions for this witness at this time.
All right, cross-examination, Ms. Swanson.
I have no questions, Your Honor.
All right, without cross-examination, may this witness be excused, Ms. Fortuna Gill?
Yes, Your Honor.
Ms. Wanchi?
Yes, Your Honor.
All right, thank you for your appearance today, girls. Any further proofs, Ms. Fortuna Gill?
I could just have about 30 seconds.
Sure.
Your Honor. No further proofs.
All right. Any proofs today, Ms. Wanchi?
No, Your Honor, thank you.
All right, motion for bind over, Ms. Fortuna Gill.
Yes, Your Honor. The people would motion for bind over on all, I believe it's 6 or 5 counts. There is a 6th count, but it's a misdemeanor. All 5 felony counts, interfering with a crime report, aggravated stalking, assault with a dangerous weapon, domestic violence, and interfering with electronic communications. We heard testimony from one witness today, that's Rosemary Arnold. She indicated that the assault in question happened at 818 Riley Street in the city of Lansing, state of Michigan, county of Ingham, making this court appropriate venue. She identified the defendant as Jacob Garcia, who was the individual who assaulted her several times in this case. We heard testimony that Mr. Garcia assaulted her several times with his fist, punching her. We have testimony that this happened multiple times, but that 5 to 6 times in this particular instance. That additionally, there was another assault where the keys are thrown at Miss Arnold's face, cutting her eye. As far as
I have that as the same date. Is that a?
Yes, the same. This is all the same date.
Okay.
Well,
I don't have that on a different date.
I believe it's all the same
Okay.
date.
That would be February 25th, November 25th.
Yes, November 25th of 2024. It's all the same date. It just begins in very early morning
Right.
hours.
And the I count 1 and count 5 are interfering with electronic communications and interfering with the crime report. What's the evidence to support the counts 1 and count 5?
Yes, Your Honor. That's where I was going next. The evidence to support count 1 and count 5 include the 911 call. The witness tried to call 911 after her eye began bleeding. She had indicated today that that call was disconnected, not of any fault to Mr. Garcia. However, when 911 called her back, Mr. Garcia had taken the phone and began punching the phone while dispatch was calling her back. The people would argue that that is enough to satisfy interfering with the crime report as well as interfering with electronic communications.
And then the count 2 stalking.
Yes, and then stalking, Your Honor, the people would argue the 40 to 50 calls after the interaction are enough to equate to the aggravated stalking charge. To be called 40 to 50 times is quite excessive, especially after such an egregious assault. And the felonious assault, of course, is with a 2-foot metal pole in question. And while it's true that Mr. Garcia did not actually hit Miss Arnold with the pole, he did threaten her with the pole. He tapped her with the pole. He hit the rear view mirror with her sitting in the driver's seat. That is enough to put a reasonable person at apprehension of an immediate battery with a dangerous weapon. And I went a little out of order, but I do believe that I have touched on all 5 of the felony charges here, and the people would request bind over. I also don't know if I mentioned the identification.
All right. There was the identification, and then the previous, where this is a third offense on the, there's a notice of third offense on the domestic violence. Is that a fair statement?
Yes, Your Honor.
Right. Response, Ms. Wanji.
Thank you, Your Honor. Your Honor, interfering with crime report, I don't believe that the elements are met here. She testified that Mr. Garcia allegedly took an 911 call back. He took the phone and allegedly damaged the phone. There was no, she did not testify that why he was allegedly damaging the phone. There was any use or unlawful use of physical force or prevent her to attempt another person from reporting the crime and things like that. So I don't believe that that the elements of interfering with crime report are met here. Arguably, the interfering with electronic communication may be met here, but not the count 1. Stalking, aggravated stalking, she did not testify that that because she was with the police when the text messages allegedly came, and she said that the police observed that, but she did not testify that she felt harassed, that she was frightened, that she was intimidated, or she was terrorized. There was no testimony regarding her being threatened by that conduct. And again, she was under protection of the police. Assault with dangerous weapon, she did not, she testified that he was touching her, but that he did not assault her with the pole. So for that one, we do believe that even though he had a metal pole, he allegedly had a metal pole, he did not assault her with that. She testified there was no testimony that he assaulted her, that he assaulted her with the metal pole. We will leave up to the discussion of court regarding the domestic violence part, and like I said earlier, maybe the interfering with electronic communication is going to leave that to the court discretion, arguably, but the test, the misdemeanor, we know that we don't need to touch that.
Right. Thank you. Ms. Fortuna Gill, response. I guess so. I want the difference part of your response to be count 1 and count 5. Count one of those counts appears to be the whatever he did to the cell phone, the interference with the cell phone, and then there's the initial 911 report that was lost. So I guess I'd like some clarification between counts 1 and 5.
Yes, Your Honor. Count 5 being the interfering with electronic communications, the defendant did willfully and maliciously prevent the means of sending an authorized communication by telephone. Those are the requirements for that charge.
Okay, is that the destruction of the telephone or like the
That would be the taking of the phone while 911 was calling and then proceeding to destroy the phone.
all right.
And count 1, the primary difference being that there was a crime report in process. So the defendant did, through an unlawful use of physical force, prevent or attempt to prevent another person from reporting a crime. So the insinuation here is that 911 is calling back. Mr. Garcia knows what has just occurred. He knows that Miss Arnold was trying to call 911, that call got disconnected. 911 is calling back to prevent her from making that crime report, takes the phone and destroys the phone. So it's the same actions, but with different elements.
If I may, for
may.
that element, Your Honor, there is the unlawful use of physical force, prevent or attempt to prevent another person. There was no physical force used at this time.
All right, the standard for preliminary examination is probable cause being the second lowest standard in criminal law, reasonable suspicion being a lower standard. And I've heard all the evidence from it's Rosemary Christine Arnold. So the court binds over on location, offense, venue, ID, and date. The date is November 25th, 2024 at 818 Riley in the city of Lansing, state of Michigan. So that suffices for the location, venue, ID. I believe that's all met at a probable cause level. It appears that the defendant, Jacob Garcia, was in a dating relationship and has been identified during the preliminary examination. So identified, and he was in a dating relationship with Miss Arnold at the time. So that's been proven at a probable cause level. And then we get to the actual offenses. In count 1, I'm going to dismiss count 1. Because I do think that, although I do think the elements of the crime are met in count 5. And so I'm going to dismiss count 1 as not bound over. Count 2 is also problematic for this court because there is an aggravated stalking, which requires some greater activity than the regular stalking, which is a 1 year. And I don't see that there's a PPO involved or anything else in any type of no contact order. It appears that there is a contact, some no contact, but I'm not willing to bind over on the aggravated stalking in count 2. So that's also not bound over. And count 1 and count 2 are not bound over. Count 3, the assault with a dangerous weapon on November 25th, 2024 is met at a probable cause level, as Mr. Garcia did with a metal pole, at least cause a reasonable person to be frightened inside the car when he struck the rearview mirror. So count 3 is bound over at a probable cause level on location of venue, ID, and date. So count 3 is bound over. Count 4 on November 25th, 2024 at 818 Riley Street. There's ample evidence that the defendant struck someone he was in a dating relationship and has a prior conviction, 2 prior convictions concerning this matter. So count 4 is also bound over. So there'll be count 3 and count 2 and count 3 and count 4 would be bound over for a probable cause level for the determination of the offenses. So count 3 and count 4 are bound over. Count 5 is bound over as interfering with electric communications as a felony. And I'm going to put it together. I'm going to put it all together. But there does seem to be that the 911 call was dropped. But then when they called back, there's ample evidence of the defendant taking the phone and then bashing the phone. And that's willfully and maliciously preventing, obstructing, or delay by any means of sending, conveyance, or delivery of an authorized communication. So count 5 is also bound over. Count 6 is a misdemeanor. So that follows as a misdemeanor. And then I'm going to add a count 7, a felonious assault pursuant to, based on the testimony that that Ms. Arnold indicated, that is pursuant to 750.82, that she was hit with the keys, that they were thrown at her and hit her in the face. And that would be the assault of dangerous weapon would be the keys, but without intending to commit the crime of murder and inflict great bodily harm. She said she bled from the being struck with the keys on November 25th at 818 Riley. And so count 7 is also bound over as, and to it, it would be the keys would be the dangerous weapon, and they were thrown at her face. So I will dismiss counts 1 and 2 is not bound over. Count 3 is bound over as charged. Count 4 is bound over as charged. Count 5 is bound over as charged. Count 6 is misdemeanor and follows the complaint. And count 7 is the new add-along, a felonious assault under 750.82. And that's also bound over as indicated. So I'm going to indicate the examination was held on today's date. So that's 4/16/2026. And so it is bound over at that time. So Mr. Garcia, your time in district court in Ingham County is done. You're off to circuit court, but you'll get your next date of appearance in circuit court from your attorney, Ms. Wanchi, all right? Bond is set at 10,000, 10%. Ms. Fortuna Gill, anything else to come to the court's attention before I sign the bind over documentation on 26-00519?
No, Your Honor, thank you.
Ms. Wanji, anything to come to the court's attention before I sign the bind over documentation?
Yes, Your Honor, regarding the bond, are you setting a new bond because you already bound out on the case?
All right, so you're requesting to modify bond down from 10,000, 10%.
I'm not requesting because you already bond over.
I already bonded out.
Bond out. You only bond out on the case.
All right, so bond is remain the same at 10,000, 10%.
Yes, sir.
All right. Any response to that, Ms. Fortuna Gill?
No, Your Honor.
All right. All right, so bond remains the same at 10,000, 10%. That it appears Mr. Garcia's already bonded out. I will sign the bind over documentation. You'll get your next date from Ms. Wanji in circuit court. Anything else for the record? 26-00519, Ms. Fortuna Gill.
Not for the people.
Ms. Wanji. All right, you're all set, Mr. Garcia. Thank you.
Thank you, sir.
Yeah.
All right.
Day.
You're not done yet.
I know. Thank you.
I think we have Miss Patrick on Mr.
Yes.
Mackey.
Yes, we do.
And then we have just that was a control date on a civil for Mr. Smith. So that's the 2:30.
Yes.
All right. Ms. Wanchi, you were busy today.
I am.
Well, tomorrow's a very light docket.
Yeah, I mean, it's gonna happen. I mean, we've had a lot of days where we don't have things go to prelim. So this, it's bound to work itself out.
Yes, I'd like it just
I can appeal.
one at a time. Yes, one every week instead of.
Have a good weekend. I will see you.
Thank you.
We'll see you, Miss Wanji.
Thank you.
So we're waiting Miss Patrick or somebody from the Patrick law office.
Yes,
Okay.
yes.
And is Mr. Mackey's not here? Or he's not incarcerated?
Yes,
I think he was a failed to appear last time.
I think so too.
Okay.
So
Right.
we will see.
Judge Flores, this is a new APA with our office, so I'm gonna read you stuff.
Oh.
What's your name, sir?
James Rowland.
James Rowland. All right. And so you're new at the Ingham County Prosecutor's Office.
Yes.
So good luck with that. This is a great, the volume of this place is great. So, I mean, we've always got something to do. So, right, Miss Wanji?
Yes.
But welcome aboard.
Thank you.
Okay.
That's why I love 54A.
You-
I'd rather be running around sweaty than bored.
Yeah, you're never bored here. There's always things to do. 55th, a little less so. 54B in East Lansing, a little less so. Here, there's always something to do. Yeah, I was in that office from 92. I was in Mecosta County Prosecutor's Office from 92 to 93, and then I was in the Ingham County office from 94 to 2005. So yeah, so I practiced in the same courtrooms. We're supposed to get new courtrooms. That's what they say.
That's what they were telling me today.
So there'll actually be some of us who missed this building, but we're really looking forward to the new building because we've had these
better temperature control.
Better temperature control. This has state-of-the-art technology about 25 years ago. but in the 1950s there was no technology, and so these walls are paper thin. They're paper thin. Yeah. So I mean, you kind of hear you hear what Judge Simmons is doing. We can't hear what Ward or Judge Buchanan's, but she can also hear us. I mean, that it's the same. Yeah. It goes both ways. So it's just tolerance. Tolerance is a pretty good thing here. We've had the same problem since the 1990s. So we're looking forward to our new building.
Are they building a new building? Or
yeah, I didn't go on the tour, but I did drive around it. There's a new building. It's on Washington Avenue.
Exists?
Yeah, it exists. Yep. It takes up about 2 blocks. Yeah, I'm starting to believe it. I never believed it before. I was always a little skeptical, There is a new building and people have toured it. David, have you toured it?
No.
We toured
the skeleton.
Yeah. I know Anithia toured it, and I know Judge Buchanan had some aspects.
It's huge.
But it is. I mean, it looks like a regular, courthouse. It doesn't. It looks very different than this building. My understanding is the mayor and they're all going. Are they going across the street from the bus station?
Yeah, they are over there by where Yama's used to be.
Yes. Yeah. I think Whitty owns some of those buildings.
Oh.
That's where his law office is.
Oh wow.
So, but he keeps saying he's gonna retire soon, so.
He's been saying that so long. Between him and Fred Blackman, it's
yeah, well, they're icons.
Yeah.
They're icons. But the fire, law enforcement, the jail, and the courts are supposed to be off of Washington. That's the plan anyway.
I look forward to it.
Yeah.
We're not ready yet.
No, we're just yakking.
Okay,
But
I'm just gonna vacuum this chair, so.
She's that red, it's really got to her.
The regular, yeah. The keys, that was good. It went over my head and case review.
Yeah, so.
But it's right there.
And I figured the stalking was problematic. That's gonna be, because it's gonna lead to a lot of,
yeah, when you were in the stalking, and I was like, well, I don't have much for you.
she's an interesting witness because I would assume that's the stroke happened after.
Yes.
No. And then she's remarried.
Yes.
Okay. No. And he's in DOC.
Yes.
So,
she was here all morning. She was a trooper.
So yeah. They said there's a lot of witnesses going around. I'm like, yeah, figure about 3 or 4 per case. I mean, And that's not only ours.
Right.
Yeah, I mean, you got to wrangle some cats, so, you know. All right, let me know
Will
when you
do.
find out, Ms. Patrick. It's nice to meet you, sir.
Thank you.
It's not the first time.
Oh.
You taught me.
Oh, really?
That's right. So,
Like Cooley?
yeah,
Yeah.
so, but that was. I'm sure this is perfect.
He,
So,
I really liked him.
I knew you were in trouble with this stuff.
I mean, I'm just bad. I don't.
It's a regular, it's a.
Sure, but not aggravated. I agree. I knew I was in trouble with the stock. Well, I didn't charge it, you know, it's not how it works. But sometimes I like it when it works that way. But the aggravated stalking, I was in trouble, and I know I was in trouble with two electronic communications.
Yeah.
I knew I was gonna lose one.
What's the difference? How do you differentiate?
Right. That's tough, but, oh, I should see if she's still here and let her know.
I'm ready to stop. I'm gonna try to head back now.
He didn't appear at that last one, and so, we both kind of vaguely remember a talk of a PCC. He doesn't care. He goes, the 21-day rule has been waived, so however you guys want to do it.
Okay, yeah, I don't care either. I have my officers on call. So it doesn't really matter. I will let Miss Patrick know. I don't know. There's like a pretty good offer. So they might
I
want to
see them
wait.
chit-chatting.
Yeah.
Oh, did you get something to eat? I have some crackers if you would like.
No, that's okay. Thank you. I have a bunch of snacks sewed in my bag.
Yeah.
I'm always prepared.
Exactly.
That's so funny. My husband was just making fun of me for that. I had him, I was like, can you go grab my, laptop charger out of my bag, work bag? And he goes in and he's like, all I can find are snacks. He's like, why do you have so many snacks in here?
Because days like today, when
Yeah.
we don't know, he's sitting there scarfing down a protein bar or whatever. So,
Yeah.
okay, why was her arm? Was it
Oh,
because
she
of
had,
him?
no, she
Oh,
had a
okay.
stroke after the fact.
Oh.
Yeah, like unrelated as far as we could tell.
Oh, wow. Okay.
She's been through it and she's so nice.
Yeah, she seemed like it. That's
She
unfortunate.
was hanging around literally since 8:30.
I know.
And she was so nice to me. Usually they just get less nice to me.
Yeah, as hours go on. No, I get it. Yeah.
I get it too. I try to tell them I get it. I mean, it's hard. If when they go, they go. And you never really know what's gonna go or what's not. So I can't tell people like, sure, like head down to the coffee shop. Like,
Yeah.
because I might need them in 30 minutes.
Right.
So,
Yeah, because there's really no, I know, because David, I was telling him, I said, Judge doesn't call, I told David, it's really Haley's show. Judge just does whatever you say, because you're the one that knows what's happening and who's here and what witnesses and whatever, so
I try to know what's happening. I do my very best. Today was a hard one for sure. There was I had a lot of cops. I had a lot of witnesses today. And then I think Miss Wanji, I think her problem was that she had so many in custody that she was trying to talk to. So she didn't get up here until, it's time to go. And I'm like, what are we doing? What do you want to do? It's crazy.
Yep.
It's what it is.
All right. Well, just knock when
Will do.
they
I'm
are
gonna
ready.
eat this bar while everyone's chatting. But as soon as they're ready, I will be ready. But yeah, I don't have any notes about treating today as a PCC. So, but if that's what Ms. Patrick thinks we're doing, I don't.
Well, like I said, he's fine with whatever, so.
Okay.
I don't know where to put it.
They're done talking and they're just chatting on the hall. David's out there chatting. And I'm like,
Move it along.
He's laying on the bench. Looks like he's sleeping.
That's where I'm ready to be. Did you guys get an answer from my office on that Maddox case?
Nope.
Still?
I had an email from some lady.
Nicole, probably.
Nicole.
Matusco.
Oh, pretty. And she's like, she goes, someone, she didn't say you, someone said I needed to reach out to you about this case. And I'm like, yes, it's old. We don't know what's happening with it.
Yeah.
You know, if there's gonna be an extradition, yada, yada. And then I've heard nothing since.
Oh.
I've just got it set off to the side. It's not anywhere, you know,
Sure.
it's just, it is what it is and it's.
Okay.
Now that I know that that's what, because I had it like, so I could always ask you, but I mean, obviously we're not in a big hurry to do anything with it, so.
Okay, I'll see what I can do.
No. It's not my bag. All right, I'm gonna go ask. Heck, because I'd like to get this one done.
What are you sneaking here?
Me?
I didn't know you, we didn't know you were sitting, I thought you was went down the other way.
Oh.
What, I thought she went down the direction.
So you want to set another date?
So, I would like to set another date for freedom.
Okay.
If you were to enter
Mhm.
two things, would you be willing to stipulate or to agree to no?
Yeah.
And would he have to be, warned over to certain people?
We could potentially do a felony plea here, but they would just need, like, I would need to know a week in advance. But I have no problem doing that, and neither does judge, they just need time.
Okay. And so,
I will check if I can do California jail.
okay, so, yeah.
And a felony plea down here.
Yeah, so, and, yeah, because one of the charges was prior to.
All right.
Right.
You can be seated. Right, Ms. Fortuna Gill, can I call these cases together?
Yes, Your Honor.
All right, so we're on the record in 2600-176 and 2600-544. That is People of the State of Michigan versus James Mackey. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Patrick.
Good afternoon, Your Honor. Melissa Patrick on behalf of James Mackey, who is here to my right.
And sir, you are James Mackey, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination on both these files. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. I believe that Mr. Mackey was not present at our last court date, is my understanding. My notes were a little unclear, but Ms. Patrick indicated to me that she was under the impression this was to be treated as a PCC.
And I think we talked about that. I think that's part of the conversation. Yeah.
With that being said, we would be requesting another preliminary examination date if the court would be okay with that. I do believe there's a resolution here. We just need a little bit more time.
And is that a fair statement, Ms. Patrick?
It is, Your Honor.
All right. I'm going to indicate that Mr. Mackey previously waived the 21-day rule on March 6th on both files. And so we'll set for a preliminary examination for this file, for both of these files, 2600-544 and 2600-176, probably at least 2 weeks out for subpoena purposes, but probably at the beginning of May sometime.
Maybe. You want May 14th or May?
What's a prelim date on that week? And how does it look?
Let's see, Friday, May 8th. We could put it on that date if you want.
All right, would that give you enough times for, that should give you enough time for subpoenas?
I would have enough time. Does that work with your schedule?
All right.
So on May 8th, I have a mediation at the Resolution Services Center at noon. We
At
could-
noon?
Yeah.
So earlier in the morning or later in the afternoon?
Yes, Your Honor.
So can we do like an earlier prelim?
Like 8:30?
Yeah.
That works. Yes.
All right. So set for prelim at 8:30 on May 8th. And that's on file 26000544. That's the second file. And then set for prelim on May 8th.
Wait, that was which one? We're doing both of them.
Yeah, both of them were on the same date. At 8:30, May 8th at 8:30. For preliminary examination on 26000176. So both files will be set for May 8th at 8:30. Anything else for the record in docket 26000544 or 26000176, Ms. Fortuna Gill?
No, Your Honor.
Ms. Patrick?
No, Your Honor, thank you.
All right, Mr. Mackey, we'll see you on that May 8th date. Thank you for your
Thank you
appearance.
very much, sir.
Good afternoon.
You too, Ms.
well.
Ms. Patrick. We had a busy morning.
I knew that.
We actually just got done.
That's what Haley told me.
I did want to ask, because I haven't done one in here yet, for felony pleas, the policy, is it a week
Yeah,
advance?
about a week for us to get the packet together, tell Marcy, and she'll get,
Yeah, but about a week.
yeah, that's fine.
Okay, I think that may be a felony
All right.
plea here.
Then, so the sentencing will be in circuit court. We'll take the felony plea here. Is that,
That's,
they just have to waive who sentences them, I
that's
think.
the way I
All
understand
right.
it.
Yeah, there's like a packet that you're gonna have to do, Marcy.
Hang on, let me finish this then.
Well, that's what happened.
David knows.
Well, that's what happened to us this morning. We had a felony plea. But the thing I was nervous about, they were gonna put Joe over there. And I'm like, Joe's not gonna know how to do that. Because it's a packet.
Yeah, it is a
Yeah.
packet, and there's all these extra steps for felony pleas.
Yeah, I've never done one. I've only
I've
watched.
done it about 5 times, 6 times, and it's,
They can do them in Buchanan frequently
Yeah.
because
Yeah.
of the sobriety court.
Yeah.
They'll do felony pleas.
we do them once in a while. I know Alish has done it here. I know Natalie's done it here.
Sure.
It's just at times when you strike while the iron's hot, make sure.
Yeah.
Or they set it for felony plea, but they asked I think one time at a pretrial, they said, will you take a felony plea? And we're like, we
Oh,
need
it
a
is,
packet.
but-
We got, we want to
Yeah.
make sure we cover all our bases.
Yeah.
There's a lot to it. It's a packet
Yes,
that it should be
it's pretty
somewhere in there.
expensive, but we've been
But
directed to
Chapel
do
County,
them
yeah.
more
Yeah.
if we can.
It makes sense.
Because there's such a
I mean,
backlog.
think
in
out
circuit
there.
court.
It is-
All right, so so that takes care of our
Emails,
morning and
information,
afternoon
why-
Yes,
with you, Ms. Fortuna Gill, and then we have,
we survived it.
yes.
At
We
one
did-
point this morning, I wasn't sure we would.
We did fine. Fine. There were a lot, I mean,
When it was 9:30 and we could only put one case on the record, I was like panicking a little, I must say.
no, but I mean, between witnesses and everything, it's gonna be all or nothing on some level.
Yes, and then tomorrow we have a few PCCs.
PCCs. And then we have a 2:30 hearing, but it's kind of a control date. David, yeah, I mean, so we set it because we're waiting to make sure that Mr. Smith has everything he needs for his discovery hearing.
Oh, okay.
And I wasn't certain that he was going to, so.
Okay.
So I set that for 2:30. So we may or may not have people show up for that.
Oh, wow.
All right, Haley, so talk to me now. What is this one?
Oh, yeah, there's a packet.
Yeah, it's.
And I do think we're gonna have a trial on Monday.
Oh, Monday.
Yeah.
We're gonna carry over to
Wait a
Tuesday.
minute.
It better not.
What's it for?
It's an assault and battery. I hope, you never know though, it's family.
Yeah, it can, I mean, you just gotta roll the dice, cause you never know if it's going. We've had everything lined up and running, and it's like, oh, we're not gonna do it. We're gonna please charge.
The trial?
Oh, Maury Curtis?
Yes.
Honestly, I don't even never know till we get here, cause you just don't know what defendant's gonna do. It's like,
You don't know what, if the witnesses are gonna actually show, they'll say they'll show, but are they showing? And last week, the witness was like, I'm here, but I have to leave at 10. I'm like, okay, well.
Oh, yeah.
well, somebody was,
So that's the one that we need a felony plea packet for?
No,
No.
I don't know that we do need a felony plea packet.
Okay, but what is that for if we do?
If it happens, it'll be on Mackey, that case we just had.
Oh,
Yeah,
oh, so I don't have to worry about it right now.
no, you do not.
Okay,
Don't,
but I should look into it to make sure I have a packet.
well, I'm gonna let you know a week in advance.
yeah,
Oh, okay, good.
yeah, it takes a.
Yeah, I'm gonna let you know a week in advance if that's happening.
Why is he?
I think just trying to,
Oh, fleeing and eluding?
yes. In the third degree.
He looked like he was tired, like what the heck?
I think he's dying.
For real?
Yeah, for real.
Oh, jeez.
Which isn't funny. I just think that's crazy. Like I'm exasperated, not laughing. So I think that they're just trying to get taken care of and they just don't want jail. Because I don't know exactly what's wrong with him, but Miss.
Oh, no, I do remember them talking about
Yeah.
that last time we were together.
Yes, so. Yeah.
That's
That's
not
hard.
good.
That's unfortunate, yeah.
Yeah. Okay.
Do you guys know when you will get a Megan replacement?
So Monday, I was gonna bring that up, because Monday and Tuesday afternoon, he has interviews.
Oh, so if we have the trial,
Yeah.
well, who knows?
So talk fast, because.
And if it's such a silly trial, it's like
What's it for?
cousins. It's an assault and battery. A cousin like tried to hit her cousin with the car. Yeah.
Well, that's gonna cause a rift in the family.
Yeah. The family stuff you never know because they can reconcile at the last minute.
And Mr. Larkin, you're here for Mr. Smith?
Yes, Your Honor. Thank you very
All
much.
right. Miss Burnett, you can come up here. All right, so we're on the record in docket 17011099. That is people of the state of Michigan, or that is LAFCU versus Latanya Burnett. Appearances for the record, Mr. Larkin.
Ted Larkin on behalf of LAFCU, Your Honor.
All right, and ma'am, you are Latanya Burnett?
Yes, sir.
Right, this time set, we previously met on March 12th, 2026 on a debtor hearing examination, and at that sometime there were some documents that were to go to a PO box. I wrote down the PO box number in Lansing to make sure, and then we set this as a control date to make sure that the documents were received. Mr. Larkin, was LAFCU able to get the documents from Ms. Burnett?
No, Your Honor.
All right. Ms. Burnett, you have not been able to transfer the documents in any way?
Your Honor, I'm in a prop right now. I'm homeless and I just had to get all my mail. I was explaining that the last time I was here. Because of my apartment had all the mold and stuff in it, the judge granted me to go ahead and move out on my lease date. So right now I have nowhere to stay and I'm trying to get the documents. My job just transferred over to the red system, which is at Speedway. They're having technical problems there. I've been telling them that I need these documents and it's already hard for me to get around, and I've explained that to them as well. So I called payroll and she said they're trying to get everything set, the new system all set up so they can get me the information that they need from me.
All right. And that, Mr. Larkin, that PO box that was the address was to be sent to. Is that correct?
Yes, Your Honor.
And so PO box, I can't read my own writing, so it's 13054.
Yes, Your Honor.
Yep. Yes, Your Honor.
All right. All right. So Miss Burnett, they're waiting for the documents. We have the debtor hearing examination. You're running into some obstacles getting them the documents.
Yes, sir.
The only thing I can think to do, Mr. Larkin, is to set this as a control date further to see that you've got it. And then on that date, there'll be essentially what it's the same as not appearing. But Ms. Burnett's here. She's indicated that she's having problems getting the documents to the PO box. I would think, I hate to extend this because we did have a debtor hearing. It was held on March 12th, but I can put it out a couple weeks if that to see that the documents get to where they need to go.
We'd be agreeable to that, Your Honor. I think that's a good idea.
Would that help, Ms. Burnett? We adjourn a couple weeks and set a control date so that we can make sure that you can get the documents that they need. And on some level, you've already started that process. It's just a matter of making sure the documents are there and you can send it to them.
Yeah, and I know that there's going to be the forwarding and stuff. And I was trying to see if I can get some help with a lawyer to see if I can even just work out some type of payment thing with them because I'm already homeless. What more can they take from me?
Yeah, let's save that for the next hearing, okay? Because if they got the documents, they're collecting on a judgment, and that's where. But they need the documents to indicate some of what you're saying. That that would be an indication that would be part of the debtor hearing relationship and documentation that you're willing to provide them that would indicate some of the struggles that you're involved in.
Yes, sure.
So let's set, I would think like the beginning of May. Would that suffice, Mr. Larkin?
That'd be great, Your Honor.
All right. So we'll reset for a control date. And so we're continuing the debtor hearing. And this is just for the documents that previously discussed, and we'd set it for probably when I get back in May.
So, like on a prelim day or an exam day?
Yeah, we could do it on Thursday or Friday, in the afternoon, but So May 7th or 8th or May 14th or 15th?
Can you be around that time or after 2:30 so I can get it off from work?
Yeah, yeah, we
I
can,
need
we
it.
can set it for 3 or 3:30.
Yeah.
Let's do May 14th.
Okay, so we'll set a control date for May 14th at 3:30. Let's see, May 14th is a Thursday at 3:30. And then if you'll you can let us know if we need the hearing because you might receive the documentation. If not, that is a control date, May 14th at 3:30. And I have PO Box 13054 for the documents to be sent for.
Yes, sir.
Anything else for the record in 1701099, Mr. Larkin?
No, Your Honor. Thanks very much.
All right, Ms. Burnett, do you have any questions of me?
No, Your Honor.
All right, you should be all set. Thank you for your appearance, sir.
Thank you, Your Honor.